People do not believe that any conflict exists, but the avoidance of all doubt.
Right.
Good morning, Your Honor. Intern Malaika Fatima requesting to practice under MCR 8.120 under the supervision of the Deputy Chief Public Defender, Lauren Brown.
You know, you having to ask permission. This now takes really a long time. It's okay. Permission to practice is granted. Go ahead.
Thank you, Your Honor. We do not believe there is any conflict between this honorable court and our office, and if any conflict is to arise, we waive that conflict so that this honorable court can hear these matters.
The court, for its part, does not believe that a conflict exists either in the Michigan court rules or the cases decided thereunder. To the extent that the conflict does exist, given the waivers, the court will consent to hear the matters. The court does call the case of the people of the state of Michigan versus Ronald Fleming.
Good morning, Your Honor. Ashley Lundy for the people.
Stephanie Cannon on behalf of Mr. Fleming, who should be appearing via Zoom. Yes. Mr. Fleming, could you state your name for the court?
Ronald Fleming.
Thank you. Your Honor, today's the date and time to go over the competency evaluation, or I'm sorry,
Competency review.
the report. And the report has been provided to me. I do believe the prosecutor has a report.
I proceed, Your Honor.
And in the report, it is indicated that my client is not competent, but they do believe he can be restored to competency within the statutory timeframe. So, Your Honor, we are asking, we will stipulate to those findings, and we are asking for another hearing regarding competency.
And Your Honor, I'm sure the court recalls we've been pending competency for quite a while on this
Yes.
file, but the defendant, I do believe, was admitted to the forensic center in June. So he's been there now for about a month and a half. So I'm optimistic that we may actually be able to get the treatment restored and done at this point. I would request also an adjournment and would stipulate to the findings in the report as provided to myself, defense, and the court, and ask the court to continue the order for his treatment and allow him to attempt to regain competency.
And just so that we're all clear, the report that I'm looking at is the July 15th report. She needs this.
Yes, Your Honor.
Yes, Your Honor.
All right. Based upon that report, the findings are, and it's been stipulated to by the parties, that the defendant still remains incompetent to stand trial at this time. The court will then continue that finding. And I will set a review hearing. Give me 90.
October 16th.
October 16th, 2025, 9 a.m.
Thank you very much, Your Honor.
Thank you, Your Honor.
Bond will continue. Thank you, Mr. Fleming.
Thank you.
Court calls the case People versus Tariq Wilson.
Stephanie Cannon on behalf of Mr. Wilson, who should be appearing via Zoom. Mr. Wilson, could you please state your name for the record? Mr. Wilson, could you state your name for the record, please?
Mr. Wilson, can you hear us? Not sure if you can hear us or not. I heard, huh?
I can try it.
All right. I'll pass them. Hear us. Court does call the case People versus Carista Riopel.
Good morning, Your Honor. Requesting permission to pursuant to Michigan Court Rule 0 under the supervision of the actually.
Oh, really? Okay. Permission to practice is granted.
Thank you, Your Honor. Christina Berger, for the people.
Morning, Judge Mike Gaddy, Assistant Public Defender on behalf of Ms. Riopelli, who is here via Zoom. If you could state your name, ma'am.
Carista Riopel.
Your Honor, I have had a chance to speak with Ms. Riopel, and we are asking to adjourn this matter so I can visit her and go over the mitigation information that we have prepared. I'd like to do that in person with her. So I'd ask the court for a couple of adjournments so I can accomplish that.
So you want 2 weeks or 3 weeks out?
Maybe 3 weeks, Judge.
August 7th. I think it's okay. Probable cause conference will be adjourned August 7th, 2025, 9 a.m.
Thank you, Judge.
Thank you.
Continue. Thank you. Court calls the case People versus Amanda Stardutes.
Morning, Your Honor. Gloria Burns here, Assistant Prosecutor, appearing on behalf of the people.
Good morning.
Good morning, Your Honor. Karma Dadush on behalf of Ms. Gardautis. Ms. Gardautis, can you please say your name for the record? Oh, she's not unmuted.
I don't know if she can. Where is
Amanda?
she? She's at MDOC.
Can you try to see if someone can unmute you at MDOC?
You're trying to force it. We got her. Ma'am, can you state your name, please?
Amanda? Can she hear us? Amanda, can you please say your name for the record?
I don't know if she can hear us.
Hmm.
Yeah, but she's not responding. They're at different facilities, correct?
No.
Yes.
Oh,
The two that couldn't hear me, because I got
Oh.
two that are unmuted but cannot hear me. All right, I'll pass that matter.
thank you, Your Honor.
You'll contact or try. Court does call the case People versus Mariah Thomas.
Karma Dadush on behalf of Ms. Thomas. Ms. Thomas, can you please say your name for the record? Okay.
Ms. Thomas, if you can hear me, if you can wave your hand, I would appreciate it. Yeah, I'm not getting.
My name isn't Miss Thomas.
Yeah, I was gonna say, I don't think that's her.
Okay, what is your name, ma'am?
My name is Anitra Coomer.
Got her.
Judge, she was adjourned via step.
She was adjourned.
And Ms. Coomer, just for I'm coming to see you on Monday. I have.
Okay. Yeah. Okay.
All right, sorry about that. I guess it was adjourned
That's
via
fine.
step. Thank you, ma'am.
Yeah.
They can put Amanda in that.
Pardon? So do we have Miss Thomas?
I thought that was Miss Thomas because.
Yeah.
Yeah, so no, we don't have.
Okay. This is going well.
Well,
So you want to adjourn that out?
well,
Was
Miss
she,
Thomas's?
pardon?
No.
Is Miss,
Miss Thomas is in the MDOC, they said they can at 11 when that facility signed.
Oh.
I can come get-
okay, so she's at 11?
Yes.
We are adjourning Amanda, but I think she has to stay here name for the record anyway.
Yes, she does.
Okay, thank you.
Well, I have to make sure it's her too.
I believe that is her.
Amanda? I just don't know why we don't have. That's it, Huron Valley.
Yes.
See if you can get through to them. Court does call the case of the People versus Donnell Young Senior.
Good morning, Your Honor. Jeff Dean, Special Assistant Attorney General, here on behalf of the people.
Good morning.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender, on behalf of Mr. Young, who's here to my right. State your name, Mr. Young.
Donnell. What are we doing?
Your Honor, I did have a chance to communicate with Ms. Williams from the AG's office. At this time, Mr. Young would like to set this matter for the preliminary examination.
All discovery is complete.
Yes, Your Honor.
The people have their witnesses available the 29th.
29th, yes, Your Honor.
Preliminary examination in person, July 29th. 2025, 9 a.m. That's before Judge Barr.
One thing, Your Honor.
Bond will, thank you. Bond will continue.
Thank you, Judge.
Your Honor.
You have a question, sir?
Oh, yes, Your Honor. I just wanted to make sure that we repeat it again on the record that we've made a pre-preliminary exam offer. And as of the date of the preliminary exam, we'll be withdrawing that offer. Just want to make sure the defendant is very clear about that. Thank you, Your
All
Honor.
right. Understand
Yes,
that.
yes, we have gone over the offer, Your Honor. It's the people's, I don't want to say standard, but the offer that they generally make.
Okay. And you understand that if it proceeds to prelim, it will be withdrawn.
Yes, sir.
All right. Very good. Thank you.
Thank you. Good morning, Your Honor.
Thank you. You too, sir. Court calls the case, People versus Hector Gonzalez.
Prisoner hearing for the people.
Morning, Your Honor. Michael Vincent on behalf of Hector Gonzalez.
Good morning, sir.
Mr. Gonzalez, put your name on the record. Hector Gonzalez, Your Honor.
Thank you.
Your Honor, today's date, time for probable cause conference. We wish to have a prelim exam on this matter.
All right. All discovery is complete.
Yes.
We'll have the witnesses available the 29th. Preliminary examination in person, July 29, 2025, 9 a.m. before Judge Washington. Who are you? No, I'm kidding. I'm kidding. I just haven't seen you in a while. I didn't recognize you. The 29th is not. Any objection from the people if I go to the next day?
We're gonna check, make sure he's there. Okay. Just make sure he's there. All right. Yeah.
Set preliminary examination August 5th, 2025, 9 a.m. before Judge Fleischer.
Thank you, Your Honor.
Bond will continue. Thank you.
Thank you, Your Honor. Thank you, Your Honor.
Court does call the case of People versus Jessica Hafner.
Your Honor, after the next order, requesting permission to practice under MCR 8.120 under the supervision of PAG.
Who? He is an intern?
Yes, seven.
He does?
Very good.
He's not old enough. All right, permission to practice is granted.
Thank you. After the next one, report.
Thank you, Your Honor. Today's the date and time set for probable cause conference. We are just asking for a brief adjournment at this time. The court should have the.
Did you state your?
I'm sorry, Judge Calvert on behalf of Ms. Hafner. Ms. Hafner, please state your name for the record.
Jessica Hafner.
Thank you.
Judge, we're just asking for an adjournment.
You're looking for an adjournment of this?
Yes, Judge.
All right. You want the 31st or the 7th?
The 7th? The 7th, please.
Probable cause conference will be adjourned August 7th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you, Judge.
Wait on the hallway for me. I can talk to you.
Mr. Wilson, can you hear me, sir?
Yes, sir.
Okay. I think something happened the first time, so let me call your case. Court does recall the case of People versus Tariq Wilson.
Stephanie Cannon on behalf of Mr. Wilson, who is appearing by Zoom. Mr. Wilson, could you please state your name for the record?
Cedric Wilson.
Thank you. All right, what are we doing?
Your Honor, I do believe I turned in a German form on this. When I attempted to make contact with him, MDOC let me know that I had to go through a lengthy process. I've started that process. He can add me to his phone call, to his visitations, and I should be able to speak with him. But in the meantime, I have filled out the application, turned it in, and I'm waiting to get approved as somebody who can come to the jail. So I'm asking for an adjournment. I do believe I asked for a 3-week adjournment because of the process.
That objection, probable cause, August 7th, 2025. Thank you, sir. Court does call the case, People versus Rahman Mohammed.
Good morning, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor appearing on behalf of the people.
Covered on behalf of Mr. Rahman. Mr. Rahman, please state your name for the record.
Rahman Mohammed. All right.
And Your Honor, we will be waiving the preliminary exam today. I have a form I'm going to ask Mr. Mohammed to sign.
All right. And sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses are committed and that you committed them?
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Your turn.
Judge, this time, waive formal reading standing.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for
July 29th at 1:30 with Judge Simpson.
July 29th, 2025, 1:30, Judge Comfy.
Thank you, Judge.
Thank you. Bond will continue. Lee, can you, or sign off on it? Court does call the case of the people versus Matthew Brown. Matthew Brown.
Yes, I'm here, Your Honor.
Correct. Ms. Constantino?
Some reason you can't get through.
Sorry, Judge.
No,
I hit the wrong button. Good morning, Your Honor. Christina Costantino on behalf of Matthew Brown.
Hey, good morning, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor appearing on behalf of the people.
all right.
And
And what are we doing?
Your Honor, I was just recently appointed to Mr. Brown's case, given that we would be asking for an adjournment of the probable cause conference.
All right. Probable cause conference will be adjourned to August 7th, 2025, 9 a.m. Bond will continue.
Thank you very much.
Thank you.
Thank you.
Amanda. Court recalls the case of People versus Amanda Scardudos.
Yes, sir. Yes, sir.
Here's now.
Good morning, Victoria Burton Harris, Chief Assistant Prosecutor again appearing on behalf of the people.
And Kelma Dadush on behalf of Ms. Scardudas. Ms. Scardudas, can you please say your name for the record?
Sure, my name's Amanda Lynn Scardudas.
Thank you.
Your Honor, we have come to a plea agreement. Unfortunately, we came to that agreement after the plea form was due, so we're asking for a very brief adjournment so that we can have that ready for the next court date.
2 weeks out. That was July 31st, 2025, 9 a.m. Bond continue.
Thank you. Ms. Scardudas, I'll talk to you, okay?
Okay, thank you so much. Y'all have a very wonderful day.
Thank
do
you.
the same. Thank you.
Thank you.
Here, he'd shoot it. You're not gonna, darn. All right. Court does call the case, People versus Andrew Patton.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Christina Costantino appearing on behalf of Mr. Patton. Mr. Patton, can you please state your name for the court?
Andrew Spencer Patton.
Thank you. What are we doing on these?
Your Honor, with regards to the case number ending in 5110, it's my understanding that discovery is complete to my knowledge, and we would be asking to have that matter set for a preliminary exam. But with regards to his other matter ending in 5154, I have just been appointed late last evening to that matter, so I would be asking that the PCC be adjourned so I can obtain discovery.
In the case ending in 5154, probable cause conference will be adjourned to August 7th, 2025, 9 a.m. Bond on that matter will continue. On the other matter, would the people have their witnesses available? Would the parties be available Will the 29th work, or did you need another day?
The 29th will work, Judge.
Will? Okay, fantastic. All right. Preliminary examination in this matter will be set in person, July 29th, 2025, 9 a.m. That's before Judge Washington.
Thank you very much, Judge.
Thank you. Bond will continue.
Thank you, Your Honor.
Thank you. Calls case People versus James Williams.
Christina Costantino appearing on behalf of Mr. Williams. Mr. Williams, can you unmute and state your name for the court?
Yes, ma'am. James Williams.
Your Honor, this is a date and time set for PCC. We have been working on mitigation, but our mitigation specialist does need some additional time to complete a mitigation report. Given that, we would be asking for an adjournment of the PCC.
Without objection, August 7th, 2025, 9 a.m. Bond continue.
Thank you very much, Judge. Have a good rest of your day.
Thank you. You too.
Thanks.
Court does call the case People versus Richard Atkins.
Brown appearing on behalf of Mr. Atkins.
Morning, Mr. Brown. Your name, sir?
Kiwan Atkins Richards.
I'm sorry, Your Honor, I was listening for Kiwan. I didn't realize that was him. If you're Richard McDuffie for the people.
All right.
We'd ask the court to set this for examination.
Discovery is complete.
Your Honor, I have a request from counsel for the 911 call. I believe that will be here by some point next week. I just want to confirm, since Mr. Atkins Richards is a co-defendant along with Mr. Correll Brown, who's represented by Mr. Kilroy, that counsel is seeking to hold separate exams in that whole exam.
Separate exam.
When is that other one set?
Mr. Brown is up for his first CCC probably right after this grant from today's docket.
We'd like the earliest date possible.
Judge, just for the record, Robert Kilwell, I was just appointed, I met with Mr. Brown last night and he wants to proceed to exam.
All right.
Just for your info.
Very good. Preliminary examination in this matter will be set July 29th, 2025, 9 a.m. That is before Judge Barr.
Thank you.
Bond will continue.
Thank you.
Case People versus Bianca Rowell.
Morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor, again appearing on behalf of the people.
Covered on behalf of Ms. Rowell. Bianca, please state your name for the court.
Bianca Rao.
Your Honor, Anali is en route to your staff.
All right.
And so I don't think that we need to worry about this matter much further.
Okay.
Before it could get to you, unfortunately, I'm sorry.
That's fine.
Okay.
Any objection to the dismissal?
What do you think, Bianca?
No.
No, Judge. No objection on this one.
Case is dismissed. I'll sign off on that when we. Court does call the case People versus Correll Brown. This is the co-defendant.
Yes.
Hey, did I get 29th bar?
Good morning, I'm Rob J. Kill on behalf of Mr. Correll Brown. Correll, just state your name.
Correll Brown.
Judge, I would, like I said, I was just appointed, but again, we met last night for a significant period of time. I do have the discovery. He's seeking a preliminary exam in this matter.
All right. People have their witnesses available on the 29th. Preliminary examination in person, July 29th, 2025, 9 a.m. before Judge Barr.
Thanks, Judge.
Your Honor, just confirming again for this record, since Mr. Brown requested a separate exam, that these are on the same.
I'm going to let Judge Barr decide whether or not the exams are held jointly or separate.
Okay.
I put them both before him. He can make that decision. Thank you.
Thanks.
Court calls case People versus Taylor Adams.
Assistant Public Defender Jay Bellinger on behalf of Mr. Adams, who approaches. Mr. Adams, can you please state your name for the record?
Taylor Adams. Thank you.
Your Honor, I am just requesting a 3-week adjournment for purposes of completing mitigation and having that reviewed by Ms. Londy.
Without objection, August 7th, 2025, 9 a.m. bond continued.
Thank you, Your Honor. I will be giving you a copy. Thank you, Your Honor.
Court calls case People versus Kimani Hamilton.
Morning, Rob Jacob on behalf of Mr. Hamilton. Judge, would you state your name for the record?
Kimani Hamilton.
Judge, I met with him last night. There's a lot of issues that we have to discuss. I'm asking for a brief adjournment.
Probable cause conference will be adjourned to July 31st, 2025, 9 a.m.
Let me see it.
Bond continued.
Thank you, Your Honor.
Court calls case People versus Abdul Rahman Al Deiti.
Testimony for the people.
This is the court defendant on behalf of Mr. Al-Daiti. He's now approaching. Please state your name for the record.
Rahman Al-Dai. Anti-pockets.
Go ahead. What are we doing?
At this time, Your Honor, we'll be setting this matter for a preliminary exam. To my knowledge, all discovery is complete.
People have their witnesses available on the 29th.
We'll try, Your Honor.
Preliminary examination in person, July 29th, 2025, 9 a.m. That is before
Judge Washington.
Judge Washington.
Thank you, Your Honor.
Thank you. Bond continued. Court calls case People versus Demond Bransford.
I'd like the class of hearing on behalf of Demond Bransford.
Pardon?
State your name for the record.
Demond Bransford.
Thank you.
Your Honor, at this time, we would like to waive over to circuit court.
Sir, is that correct?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants found over to circuit court on all three counts. Your turn.
We acknowledge the information and receipt of the information, and we waive its reading, and the client stands mute.
Defendant having waived for more reading, standing mute, court will enter a not guilty plea. As to all counts, pretrial will be set for
July 30th at 1:30 with Judge Conlon.
July 30th, 2025, 1:30, Judge Conlon. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Amar Amadou. Ms. Cannon,
Oh, I got it, sorry.
so I don't get to yell at her, I get to yell at you.
No, I'm sorry, she just kind of handed them off to me, Your Honor, and like left. So, I'm sorry, what was the name, Your Honor?
Amadou.
Yes, thank you, Your Honor. Student Attorney Kara Rosengen requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Hannah Apple on behalf of Mr. Amadou.
Permission to practice is granted.
Thank you, Your Honor.
Where's your client?
I'm sure I don't have any idea. I'm sorry, you'd have to ask Miss Cannon. You'd have to ask Miss Cannon. I'm going to reiterate, I'm sure I have no idea. But we are asking for an adjournment in this case, Your Honor. We're requesting a 2-week adjournment.
You can hand me that, it's not gonna happen. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Court does call the case of the People versus Troy Brumfield.
Assistant Public Defender Hannah Ashwell here on behalf of Mr. Brumfield, who's approaching now. Mr. Brumfield, will you state your name for the record?
Troy Brumfield.
Thank you.
Your Honor, Mr. Brumfield wishes to waive his preliminary exam today.
All right. Is that correct, sir?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Thank you. Your Honor, defense would acknowledge receipt of the information, waive reading, and my client would stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 28th at 1:30 with Judge Simpson.
July 28, 2025, 1:30, Judge Hamoud. Bond will continue.
Thank you.
Sign off. Court does call the case People versus Dominic Billing.
Student Attorney Kara Rosengren on behalf of Mr. Billings. Could you say your name for the court?
Dominic Billing.
All right.
Your Honor, Mr. Billings is going to waive his right to preliminary exam today.
All right. Sir, is that a correct statement?
That is.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, I do.
Understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Mr. Billing waives formal reading and stands mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 8th at 1:30 with Judge Simpson.
September 8, 2025, 1:30, Judge Hamoud.
Thank you, Your Honor.
Bond will continue. They're gonna need that. I didn't pull it out. Court does call the case of the People versus Robin Finney.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Ms. Finney, who's approaching. Ms. Finney, can you state your name for the court?
Yes, Robin Lee Finney.
Thank you.
Thank you. And Your Honor, I apologize. I do have a green sheet. I am requesting an adjournment, a 2-week adjournment in this matter for continued discussion with the APA.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case of the People versus April Black.
Stephanie Cannon on behalf of Roulette. April Black.
Thank you.
And Your Honor, in this case, we are asking for a brief adjournment for mitigation purposes. My client has provided me some information. I need to provide that to the prosecutor's office.
Probable cause conference, April 7th, or August 7th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor. August 2nd. Oh, we want to address the cover. Your Honor, may I address bond? I'm so sorry. May I address?
He's out.
What?
Go ahead.
Oh, I didn't hear what you said, Your Honor. I'm so sorry. Your Honor.
Happy to change it.
Oh, he's out.
Go.
You're not going to change it?
No, I don't know what you're asking.
Oh, so Your Honor, my client is currently on tether. We're asking that the tether be removed. I have reviewed her file and the information in this case. She is charged with malicious destruction of property and resisting an officer. The police report itself is replete with information that has nothing to do with her resisting charge. It's my understanding, since then, she's been very cooperative with the police regarding the situation that pulled the police to the scene, which was a shooting. My client wasn't a part of the shooting. She was a victim of the shooting, her and her mother. In their haste to get away, the police did stop them. And my client has allegedly done some behaviors where she destroys a little bit of property, maybe we'll say, and she's going to pay for that. She understands that she has to pay for that, and she did resist. However, my client in that time frame was exceptionally emotionally distraught from the shooting. Her whole thing was to get away from the scene, to leave. And yet somehow, some way, my client, and again, she's done lineups, she's done everything the police have requested of her regarding that shooting. She has no other criminal history. She's not a threat to the public. She's come to every court appearance, and she will continue to come to every court appearance. We're asking that the GPS tether be removed, Your Honor. In addition, it won't allow her to go see her mom when her and her mom were trying to get away from the situation. And so she's also confused as to why the court is keeping her from interacting with her mom when her and her mom were victims trying to get away from the scene.
Response.
Yes, Your Honor, I did the arraignment on this, so that perhaps gives me a little bit more insight. So what happened here is, in my understanding, there was not actually a shooting, it was an FA of Ms. Black's mother. And the reason that she has that color is that Ms. Black is accused of repeatedly trying to go to the home of the people she believed did that, which is just a few doors down from her mother. So there's no order that prevents contact with her mother. The order prevents contact with her mother because at the time this happened, Ms. Black was visiting her mother. And when the police responded, they actually used a lot of restraint with Ms. Black as far as they tried to just get her to calm down because they understood she was upset. She repeatedly told the police that she was going to the residence where the suspects were. And they kept telling her, no, you're not. And she kept telling them, yes, I am, and kept trying to walk over there. They had to physically stop her multiple times. Eventually, they ended up having her sit in the car, try to give her some time to calm down. When they let her leave from the car, she again said she was going there. And so, Your Honor, she calm down as far as going to that location, that there was that concern for safety. So there's no attempt to stop her from seeing her mother and to keep her from going to that other location. That's just a few houses down.
Your Honor, and I'm sorry, because she just finished. I'm so sorry. Please continue.
So that's why she had the tether. There could not be a hot zone because Ms. Black lived so close to the location. And so to resolve that issue, it was a tether with a no-go instead of a tether with a hot zone. So that's why there's that.
Gotcha. And I don't see an order prohibiting contact with the mother, so I don't know where that.
So she goes there, she takes her children there. This is somewhere that she used to go every single day because she takes her mother there. Now, we understand that she's not been charged for the felonious assault of anyone. She didn't go to those people's houses. She's not trying to go to those people's houses. She's calmed down a great deal.
But the allegation is that she tried to go there on that night, that she tried to go toward where these people were that committed the other alleged act.
Yes, Your Honor. So that is the situation. But my client doesn't want to go there. She's calmed down. She's never been there before. She has no intention of going to these people's house. It was just an emotional situation at that time. She's not that person, Your Honor. And she's asking for the court to give her the opportunity to show that that was a momentary lapse of judgment that she will not go back to.
Motion to modify bond is denied. Bond will continue. The GPS will continue.
Thank you, Your Honor.
Court does call the case of the people versus Antoine Brown.
And is that on behalf of the people, Your Honor?
Carolyn Foster Tucker on behalf of Antoine Brown.
Your name, sir?
Antoine Brown.
Thank you.
And Your Honor, we are requesting a preliminary exam in this matter.
All right. All discovery is complete.
To my knowledge.
People have their witnesses available the 29th.
Yes, Your Honor, and I do believe as far as discovery, we did request the 911 call early this week, so it should be here prior to exam.
Okay.
Okay. Preliminary examination in person will be set July 29th, 2025, 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Oh, you're going to get one. Court calls the case. People versus Ibrahim Siddiqui.
Alexander on behalf of the people, Your Honor.
Assistant Public Defender Nicholas Bukovich, on behalf of Mr. Diakite in matters that end in 1232 and 1233.
Morning, I'm Rob J. Kilwell. Judge, I'm on 5153.
Okay. What are we doing? Sir, Mr. Dick, he's still muted.
Yeah.
Jim, why is he brought up?
Oh, there he is. Sir, can you state your name, please?
Ibrahim Jakaite.
Okay.
What
are we doing?
In the matters that I represent, Mr. Diakete on 1232 and 1233, we would be requesting a set for a preliminary exam. To my knowledge, all discovery is complete in both of those cases.
Same with 51, 53.
You want an exam set?
Yes, Your Honor. I did meet with him last night.
So keep an eye on.
People have their witnesses available the 29th.
We'll do our best, Your Honor.
Preliminary examination will be set in person July 29th, 2025, 9 a.m. before Judge
Judge Washington.
Washington.
And Your Honor, when appropriate, my client would like me to address bond.
Go ahead.
Yes, Your Honor. Mr. Diakate would like me to request a release on tether. He does not reside at the same location as the complaining witness in the 1232 case. Prior to incarceration, he began working full-time as a caregiver. He'd like to be able to return to that work. He does not have to be, he has no reason to be in contact with the alleged complaining witness in this case. No children in common, no residents in common. He does have his own transportation or be able to return to court. He does have ties to the state of Michigan as he has family who resides within the state in different cities. So he'll be requesting a tether with a release on tether, personal reconnaissance bond for release on tether in his cases.
Your Honor, just two things on my case. I'm trying to figure out what the bond is. Does your record show what the bond is on the 23 case?
The 23 case bond is 1,010%.
All right, thank you, Judge. I would just echo that, Judge, request for bond. And again, this is a 23 case that happened in the jail.
Response?
Your Honor, I would object to any modification of bond. This defendant is looking at 3 cases here, and I'll go through each one by one. In his R&O case, he is an officer tried to stop the fight and told the officer that he was going to kill him when he got out of jail. At his next case, he was throwing rocks at someone's windows. Officers arrived, saw a motorcycle leaving, confirmed it was the defendant, and a pursuit began where he reached speeds of over 100 miles per hour in a 45-mile-per-hour posted zone. He was caught after his motorcycle had stalled, and the motorcycle turned out to be stolen. And then in his third case, him and the victim who were working together, had a dating relationship. An employee at that restaurant called 911 to report that the victim had been dragged from the restaurant, kicking and screaming, to a car. And the colleagues at work had saw visible scratches on her face. And after being put in the car, the defendant then drove away, and the victim jumped from the car, and officers found her in the middle of the roadway. I also wanted to report that he has a previous DD conviction from 2023, and he currently has a hold from Delta County with bond denied. So I would be asking that bond remain as set in this case, Your Honor.
Anything else?
No, Your Honor.
All right. Given all of those circumstances, motion for bond reduction is denied. Bond will continue in all 3 matters.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case. The cases of the people versus Brian Gerard.
Appearing on behalf of Brian Gerard. Please say your name for the record.
Brian Gerard.
Your Honor, at this time, we are requesting to adjourn this matter for pending negotiations with the prosecutor.
Probable cause conference will be adjourned to July 31st, 2025, 9 a.m. Bond will continue in these matters.
Thank you, Your Honor.
Court does call the case of people versus Cameron Jones.
If you ever to make for the people.
Carolyn Foster Tucker on behalf of Tamarian Jones.
Your name?
Tamarian Jones.
Thank you.
And Your Honor, we're just requesting a brief adjournment in this matter. I've talked to APA McDuffie, and she indicates that there's an offer that we need to discuss.
August 7th, 2025, 9 a.m. Bond continues.
Your Honor.
Thank you. The People versus Hiram Haywood.
Ready.
Good morning, Victoria Burton here, Chief Assistant Prosecutor again here on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Hiram Haywood.
Your name, sir?
Hiram Haywood.
All right.
Your Honor, today is the date and time set for the probable cause conference. However, we are working towards drug court resolution. We need time to be able to put in a request so that we can make sure that he can be accepted to that drug court. So we're going to ask for a 2-week adjournment by the time we.
And I don't mind giving you the 2 weeks, but the timing that I was getting yesterday, I don't know that that's going to happen. To be honest with you, so I'm going to go. I certainly don't want to go so far out, but I'm going to go August 7th, just one more week out. 2 weeks. August 7th, 2025, 9 a.m. His bond will come.
Thank you, Your Honor.
Thank you. Court does call the case People versus Zaria Brand.
Pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecutor Attorney Alexander.
So you're under supervision of who? So it's Zenda today? You guys made up? Okay, well, never mind. I don't know. Something Douglas was in the middle of it all. All right. Permission to practice is granted.
Good morning, Your Honor. Roba Hamden requesting permission to practice. I'm so
Now, it's okay. You're scared? Am I doing it?
I just my mind went blank for a
You
second.
did it? Mine does that too. Go ahead. Just hold it. Do me a favor.
Requesting
Hold on.
Oh, okay.
Take a deep breath.
I'm breathing fine, Your Honor.
Apparently not.
My mind just went blank.
All right. All right. Just relax. Okay. Go ahead.
Good morning, Your Honor. Roba Hamden requesting permission to practice under MCR 8.120 under the supervision of Assistant Public Defender Jay Ballinger.
Okay, very good.
Sorry, Your Honor.
Oh, so it's his fault. I get it.
I don't know. I got thrown off.
It's Ballinger's fault. Trust me.
Probably you don't have to apologize.
All right. Your name, ma'am?
Zaria Brand.
Thank you. All right. What are you doing?
Your Honor, mitigation information was sent to Prosecutor Zenda for review. The prosecutor is seeking adjournment to review.
To look all of that over. All right.
I'm sorry?
That needs to be reviewed and an answer given.
Yes, and they also wanted to speak to the claiming witness as well.
Pardon?
They also wanted to speak with the claiming witness.
Yeah. Okay. Probable cause conference, August 7th, 2025, 9 a.m. Bond continued.
Thanks, Your Honor. I'm sorry about that.
Sorry about what?
My mind just went blank. I don't know.
It's okay. You made it through it, right?
Yeah.
Sometimes that's what we got to do.
Thank you.
Just get to the end of it. Court does call the case. People versus Justin Hodge.
Roba Hamden. I am here with and on behalf of Justin Hodge. Can you please state your name for the record?
Justin Paul Hodge.
Thank you.
Your Honor, we would like to set preliminary examination at this time.
All right. Is all discovery complete?
To the best of my knowledge.
All right. People have their witnesses available the 29th.
Try our best.
Preliminary examination in person, July 29th, 2025, 9 a.m. before Judge Barr.
And then when appropriate, we would like to address bond as well.
Of course you will. Go ahead.
Your Honor, my client is asking for contact with his 2 children to be reinstated. He advises that he would not need to be in contact with the claiming witness in order to do so.
Response.
Your Honor, we would object to any modification of bond. The defendant was on probation when this case occurred for another domestic violence case in Wayne County. He's currently being held out of reign for that. He currently has a hold out of reign for that DV with bond being set at $1,570. And this current case involves the defendant having an argument with his girlfriend, taking her phone and smashing it, and he's admitted to throwing the phone. So at this point, we believe bond is set as appropriate.
Were the children there at the time?
They were.
They were present at the time of
The 2-year-old was present.
the 2-year-old. So one of the children was there. Any other?
No, Your Honor.
All right. Motion for bond modification is denied at this time. Bond will continue with the conditions. Thank you. That's the case of the people versus Jamie Burke.
If you ever to make that.
And with that, on behalf of Mr. Burke, who is here in person, can you please say your name for the record?
Yes, good morning, Your Honor. My name is Jamie Kaylee Burke.
Thank you.
Thank you, Your Honor.
Your Honor, we were going to be requesting an adjournment. We had the wrong phone number for Mr. Burke. We had his mother's phone number. That's how we have been reaching him in the past. She is now hospitalized. She was this week and still is. We were going to be asking for a 3-week adjournment. So until he's
August
able.
7th, 2025, 9 a.m.
You're wonderful, Judge. Thank you very much,
Thank you
Your
for
Honor.
saying that. Not everybody agrees, but I think you're right.
Honestly, thank you.
All right.
Fairly.
Thank you.
Really appreciate that. And it was for August 7th at 9 a.m.
Yes, sir.
Right here, correct? Same building, same floor?
Building.
Fantastic. Look forward to seeing you. Thank you, Your Honor. I hope you have a good night.
Thank you, Your Honor.
Thank you.
Let's call the case people versus Kyle Humphreys.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Humphreys.
Okay, go ahead.
Hi, Your Honor. We'll be requesting a brief adjournment for some further negotiations. Mr. Humphreys we've been working on a release for treatment with him. I've been in contact with Sarah Stewart, and he may be released for treatment soon, so that may play a part in the plea negotiations.
And that's correct, Your Honor.
All right. Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continue. Let's call the case of the people versus Frank Clark.
And with that, on behalf of Mr. Clark, who should be appearing by Zoom.
Frank Clark.
Say your name again, sir.
Frank Clark.
I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of attempted resisting and obstructing a police officer. The 1-year offense. Upon a successful plea to that added count 2, count 1 would be dismissed. There is a prosecutor recommendation that indicates here of HIDA. That's the court's full understanding of the agreement.
Yes, Your Honor.
Yes, Your Honor.
Sir, can you please raise your right hand? He's gonna have to have more light where he is. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
State your name again, please.
Frank.
Full name.
Frank Clark.
Thank you.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes.
You also understand, sir, that while I'm taking your plea, froze. I don't. All right, well, you still there? Not on my one screen. Okay. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before a judge. Perry in the 15th District Court. You understand that, sir?
Actually, I didn't. Can I get a better understanding?
Judge Simpson will not be the judge who is sentencing you. You'll be sentenced in front of another judge.
Did you
Okay.
discuss that with your attorney, sir?
That was in one of the
Yeah,
paragraphs. Yeah.
yeah,
You did?
yes,
Okay, so you understand that that's what will happen. I will be taking the factual basis for your plea, but Judge Perry will be the one imposing sentence.
yes, I understand.
Okay, and you do understand also, since you had a question about that, that you do have a right to have the judge who takes your plea also sentence you, and that you're waiving that right.
Yes,
All right. Now, understanding all of that, sir, do you still wish to plead guilty to this charge?
yes,
To the charge of attempted resisting and obstructing a police officer, how do you plead?
guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
You went over and a advice of rights form with your attorney,
yes, Your Honor.
and you gave her permission to affix your name to that.
Yes,
Do you have any questions regarding any of those rights?
no,
You understand that the trial rights, which are contained in paragraph 5, that you're giving up those rights as well as all the rights that are contained on that form.
yeah, yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or on parole?
no, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily,
Yes,
of your own free will,
yes,
and because you believe that you were indeed guilty of this offense?
yes,
August 31st, 2024, at the location of East William Street near Maynard in the city of Ann Arbor, Washtenaw County, state of Michigan, did you come into contact with police officers from the Ann Arbor Police Department?
yes.
What happened that makes you think that you're guilty of this offense?
Body cam footage.
What happened on that day that was captured on the body cam footage that makes you believe you are guilty of this offense?
I heard the officer say it, talking to me.
Your Honor, may I go out there?
I was shot.
Okay. Mr. Clark, what is it that you did after the police officer tried to speak to you that makes you guilty of this offense?
I was running.
Running from?
Yes, I was running from the police.
Okay, so the officer tried to have you stop to talk to you?
It appears so, yes.
Does it appear so, or is that what happened, Mr. Clark? Were they trying to talk to you that day?
Yes,
Okay, and did you take off right after that and run away from them?
well, yeah, I was running, yes.
Well, when the officer said your name, did he not?
No,
Okay, did he ask you then to stop?
yes,
Okay, and when the officer asked you to stop, did you understand that the officer wanted to talk to you?
at the time, no.
Your Honor, we likely should have done a no contest. I believe he was intoxicated at the time that this happened.
So there might be some memory issues happening right
No, not my memory. No, I recall, but
Okay, so here's what we're gonna do. Here's what we're gonna do. Where are you right now?
I'm in my home.
In Ann Arbor?
No, I don't
Ohio.
live in Michigan.
Are you in Ohio?
Yes.
Mr. Clark? Okay.
Do you remember what happened that day
Yes.
clearly?
Yes,
Sir, do
Your
you
Honor.
clearly remember what happened?
Yes, Your Honor.
All right. So you came into contact with the officer. What did the officer say to you?
He said, "Let me talk to you for a moment." And he was talking to me and my brother.
Okay. When the officer said, "Let me talk to you for a moment," what did you then do?
I talked to him for a second and then I ran.
Okay. At the time that you ran, did you know that was the officer done talking with you?
No.
Okay, so you knew the officer still needed to talk to you and you ran.
Yes.
Sir, you understand that if I accept your plea, that if you commit some type of misconduct between the time of this plea and the sentencing, that any sentence recommendation or evaluation of the case, the court would not be bound by. You understand that?
Yes, sir.
All
Yes,
right.
Your Honor.
Okay. Is counsel aware of any other promises, threats, or inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
August 1st at 8:30 a.m. with Judge Perry.
August 1st, 2025, 8:30 before Judge Perry.
Thank you.
Bond continued. Thank you.
Thank you, Your Honor.
Court does call the case People versus Serrano Johnson. Serrano Johnson.
Permission to approach the prosecutor.
Everybody want to put their appearance on and then ask?
Ron Brown appearing on behalf of Mr. Johnson.
Your name, sir? Serrano Johnson. You may approach.
From Second Baptist Church, Reverend.
Moment, depending on the outcome of your bond motion. Go ahead.
Your Honor, provided the court with a letter from Second Baptist Church, Reverend George Waddles. The pastor is present here in court today along with
I do see you.
my client's
Hello,
family
Pastor.
members.
Go ahead.
If released, he would live at 111 North Adams, Apartment 1 in Ypsilanti. By profession, he's a chef. He's been a resident of Michigan approximately 20 years. Like I said, he attends Second Baptist Church. He also volunteers at Hope House. And Your Honor, he's a caregiver for family members. So he has a lot of things going on. He volunteers in his community. I understand from the last hearing that he was not candid with the court as to his consumption of alcohol. But and I'm
not candid would be an understatement. I mean, he just outright lied.
Well, I wasn't there.
That makes it no less a lie.
I'm asking if you want to hear from him.
I'll-
A humble apology.
I will certainly hear from him, but not if he's gonna sort of spew that garbage he was giving me the last time, because that's how he ended up in custody.
I apologize, Your Honor. I panicked. I apologize. Yes, I did consume.
Pardon?
Yes, I did consume, of course. But yeah, I panicked when I was talking to the guy. I apologize for our last encounter.
You consumed alcohol and when I tried to get you to just tell me that, you just lied to me. Right?
Yes, I tried to go back and you told me.
Pardon?
I tried to go back on it, but it's too late. I had already said it. So, yeah. I apologize, Your Honor.
So on the date that you drank, what happened?
What was the trigger? What made you drink?
Working on somebody's funeral arrangements and drink a couple beers, drink a few beers.
Okay, so did you have any O'Doul's?
At first, but
At first, okay. How many O'Doul's did you have? Six. And then you had how many?
Labatt's about four.
Sure. Okay, now you know that's different than what you told me.
I was trying to tell you, but you told Mr. Allen
You were trying to tell me what?
nothing. That's what I
No,
told
no, 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 no. Let me tell you what you said, because I remember it very clearly. You told me that you had six O'Doul's. I told you to get to the levels that you were, if you were just drinking O'Doul's, because you were insistent on that, you would have had to have a little over a case of O'Doul's. Remember that?
Yes.
Then, at that point, you realized, well, he looks stupid, but he's not. And then you started telling me that you had two beers. Remember that? What?
Yes, Your Honor.
And I knew, given the level that's on here, that wasn't true. Now, the other things that you told me was that you were in treatment. Remember that?
Treatment. Trying to go to treatment.
Well, okay. Yes.
I'm just trying to.
I don't understand the question.
You said it to me.
He said at the last.
Did you or did you not tell me that you were
wasn't
in
there.
treatment or had started treatment?
We were looking for a place to go to treatment. That's where we're starting, trying to go. Yes. My insurance is different.
Let me ask you this. When you made the statement about treatment, were you trying to get this court to believe that you were in treatment?
No.
You're saying no?
Self-incriminate myself. I don't know what you want me to tell
You
you.
don't want to self-incriminate yourself?
Already done.
So see, okay. And I know you know this, but I'm just gonna remind you. That's what happens when you lie.
And I apologize.
I know a whole lot more than it appears that I know. And the moment you told the people at Community Corrections about O'Doul's, I knew you were lying. That was my first start. Now, if you can tell me that you can put down about a case and 2 or 1 beer, about 25 beers, and not go to the bathroom, because that's the only way that was gonna happen with O'Doul's. Yeah, so that's was kind of the stupidity of the lie. And then it just got worse for me. And then as it got worse, then you ended up going to jail.
I get it. Oh, I get it.
So how are you going to get in? You have insurance to cover treatment?
We're working on that. We just changed insurance, so it's not clear about.
His family's here, Your Honor.
They're
Oh, I
working it
know
out.
they're here, but you told me, Mr. Brown, at the bench that he's got insurance that will cover his insurance. And I'm just asking, will his insurance cover treatment?
We're working on that now to get a definite. Yes, it will cover some sort of treatment. Yeah.
Anything from the people?
Your Honor, people do believe that Mr. Johnson is in dire need of treatment. We do have some concerns after the statement today. He may still not understand the extent he needs treatment, Your Honor. And I did have a chance to look at the letter that Mr. Brown provided that was from Mr. Johnson's pastor. It is a lovely letter and talks about the lovely things that Mr. Johnson has done. And the people aren't arguing that Mr. Johnson is a bad person at no point. And we allege that, we're alleging that he committed a crime, and it would appear that perhaps the root of that could have been an alcohol addiction, Your Honor. And we think without treatment, that situation could reoccur. And it's not clear that Mr. Johnson understands that or the need for treatment. So we do have some concern there.
Anything else, Mr. Brown?
No, Your Honor.
Johnson, here's what I'm going to do. I'm going to first of all adjourn his probable cause conference to August 7th, 2025, 9 a.m. With reference to his bond, I will set his bond at a $25,000 personal recognizance bond. On your release, you are to report to the Department of Community Corrections for placement on a scram tether because you were on a
Correct.
You're going to go on a scram tether, so I'm going to monitor you 24/7 for any alcohol consumption. I'm also going to order that within the next 10 days, defendant is to be enrolled in treatment. He is to notify the court that and the prosecutor's office that he is in treatment.
How many days?
He's got 10 days to do it. If he doesn't get in, I'm issuing a warrant, or he might as well just come over to jail and turn himself in, quite frankly, because I'm going to issue a warrant and I'm going to have him picked up.
Understood.
You understand all of that, sir?
I do.
Thank you.
Thank you, Your Honor.
No, this will do that. Okay. Thank you, sir. Court does call the case of the people versus Michelle Campbell. Campbell, can you state your name, please? What's your name?
Michelle Campbell.
Thank you.
Your Honor, at this time, we are requesting for an adjournment due to pending negotiations.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of people versus Antoine Coleman.
With and on behalf of Mr. Coleman, who is approaching.
Thank you.
Your Honor, Mr. Coleman has completed his 14B recovery court evaluation. He was accepted as of 4 a.m. last night, so we didn't have time to do the plea. If we can have a very short adjournment so we can get that done, that would be great, Your Honor. Thank you.
Shortest I've got is the 31st.
That's okay. Thank you.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued. All right. Thank you, sir. Court calls case people versus Vincent Lambert. It's Mr. Brown's case. Ron Brown.
Ron Brown, thing on behalf of Lambert. Your Honor, we're requesting adjournment. I filled out the green papers.
What's the purpose of the adjournment?
Additional discovery.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Sean Cotton.
Stephanie Cannon on behalf of Mr. Cotton, who is appearing by Zoom, Your Honor. Mr. Cotton, could you please state your name for the record?
Great. If we could hear you, you need to unmute. Thank you.
Sean Cotton.
Thank you.
Your Honor, we are going to go ahead and set this for a preliminary exam.
All discoveries complete.
To my knowledge, yes, Your Honor.
People have their witnesses available the 29th.
Your Honor, we'll try our best, and just for the record, I discussed with counsel that Mr. Cotton's offer that was previously extended is hereby rescinded.
Preliminary examination in person will be set July 29th, 2025, 9 a.m. before Judge Washington.
Thank you so much, Your Honor.
Bond continued. Court calls the case of the people versus Paris Lester.
Chairman, on behalf of Mr. Lester. Say your name for the record.
Paris Lester.
You're requesting an adjournment.
Yes, please, Your Honor, just to
Probable
continue.
cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case people versus Curtis Damon.
And Lori Yackey, Assistant Public Defender, with and on behalf of Mr. Damon. Mr. Damon, could you state your name for the court?
Yes, Curtis Mitchell Damon.
Thank you.
And Your Honor, I have been in discussion with the APA. I am asking for one more adjournment to get paperwork of Mr. Damon's progress, completion of inpatient treatment and progress of continuing treatment.
Probable cause conference, August 7th, 2025, 9 a.m. bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Anthony Miller.
Chairman Radish, on behalf of Mr. Miller, please state your name for the record.
Anthony Lavelle Miller.
Thank you. You're requesting an adjournment.
Yes, Your Honor, and a chance to address
Discovery.
one. Yes, Your Honor.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. bond continued.
Your Honor, can I address one, please?
Go ahead.
Your Honor, Mr. Miller, I believe it's the second TCC, he failed to appear at his last court hearing, but he had been in custody in Wayne at the time. That's why he failed to appear. He was there from September to April, he tells me. So we are going to be asking for either a reduction or a personal recognizance fund. Your Honor, he.
September to April.
Yes,
Yes.
sir. Yes, Your Honor.
He has a part-time job. He works at a gas station. He has a sister that he can go to stay with or a friend. But the only reason he failed to appear is because of that, and he will make it all future court hearing.
And how did he come back into custody?
A warrant that was picked up from released from Oakland County. I was released from Oakland County, and then
This warrant was up.
right. They didn't pick me up. They released me, and then they picked me up and
So when were you released from Oakland County?
You told me September to April?
No, I was released from Wayne County, but I was picked up on a warrant in Oakland County after doing my 9 months from Wayne County. So I was picked up on a warrant from Oakland County 3 days prior to arriving here. And Washtenaw County did when I was released from Oakland County, Washtenaw County didn't come to travel to get me, and they released me from Oakland County, and then I went to Wyandotte, and then my officer was taking giving me a lift, and he asked for my, I gave him my name. He said, "Oh, you have to take care of one in Washtenaw County." So he was giving me a lift. I asked him for a ride because I wasn't hiding anything. So he said it was protocol to get the name, so I gave my name. I wasn't hiding anything. He said, "Well, you have a warrant."
You didn't turn yourself in, I guess is my point,
Yeah.
right? You came into contact with the police. They told you had a warrant. They told you had a warrant. What'd you do?
Did you turn
Did
yourself
they
in?
take you into custody at that point?
Yeah,
They took you into custody, and that's how you got here.
right.
Okay.
But the reason I failed to come to report to court because I was in from September, but I understand what you're saying. So,
What do you understand I'm saying?
Cause I felt, after being released, I didn't.
You should have come down here and taken care of your warrants
What,
because you knew you didn't appear.
no, cause I failed to appear cause I was in custody, but.
Once you were released, you didn't turn yourself in
Yeah,
after, even though you had a warrant?
Right.
You knew you had a
I
warrant.
didn't turn myself in, so, but I throw myself on the mercy of the court. I will report to I'm not a threat to.
Are you on probation anywhere else?
In Wayne County.
You're still on probation in Wayne?
Yeah, from the release of my 9 months that I did.
And what's going on in Oakland County?
Nothing.
What's the first?
Everything, they ran it concurrent. They ran my sentence concurrent with Wayne County for the 9 months that I did. But as I said, I'm no threat to society and to humanity. And and I will make my court appointments. I'm not trying to avoid the law or my responsibilities. It was just that the hindrance was because I was in custody, but I told myself
right. But then when you weren't in custody, you didn't come down here.
Your Honor, if I may add, having court cases in 3 different counties is likely a lot.
Yeah, that's why you maybe should confine your criminal activity to one place.
Alleged criminal activity, Your Honor.
Well, they're not alleged.
Your Honor, if you give him one more chance,
Yeah, I know.
please.
I would ask you, can we, follow on the personal bond that, that I had, I will make all my court appointments. I'm not gonna try to avoid it to come up in front of you again and say, well,
And he will contact us if he's confused or has a lot of court dates out of a lot of different counties. He will.
Where is he living?
He has a sister, he has a friend in Detroit that he could stay with, or his sister at I don't know how to say that. Wind up.
19783, still Detroit, Michigan.
And how do I know he can stay there?
Well, my probation officer, that's where
Go ahead.
my probation that's where my probation is located in Detroit, Michigan. So
How do you know that he could stay with his sister?
that's where my probation is.
Sure.
Was that the question?
It was.
Have you talked to your sister and she's allowing you to stay there?
Yeah.
Well, I would need some indication as to exactly where he's staying before I'm gonna even consider a release. So at this time, motion for bond reduction is denied.
Thank you, Your Honor.
Court calls case People versus Jay Dingman.
And the public defender on behalf.
Damon? Your Honor, I've looked in the hallway and in the courtroom. I haven't seen Mr. Dingman. I did speak to him on the phone yesterday.
Did see him?
I did not. I did speak to him on the phone yesterday. I can't explain his whereabouts today. If we could approach briefly, just very briefly, Judge.
No, we were moving along so good. Come on. Bench warrant will issue for defendant's failure to appear. Bond is setting him at $10,000 cash. Sure, warrant will issue immediately.
Thank you.
Court calls the case People versus Carl Murray.
Cameron Adush on behalf of Mr. Murray, who is approaching. Can you please say your name for the record?
Carl Murray.
Your Honor, we're asking for an adjournment. He does have a PCC on another case on the 22nd. We would love to resolve them together, so if we can have an adjournment to that date.
5 days out.
Yeah. I've already reviewed the discovery on this case. I just need to do it on the other case.
Thank 2025, and bond continues.
Thank you.
Okay. Court calls case People versus Thomas Lee Ellis.
And Lord Yagi, Assistant Public Defender, with and on behalf of Ms. Ellis, who's approaching.
Your name, sir?
Sorry. Thomas Ellis.
Okay.
Your Honor, we are asking for another adjournment. Mr. Ellis did do the screening and assessment for 14B, but we need a follow-up letter from his doctor. So we are asking for an adjournment for that reason. He's going to see his doctor today. So.
Probable cause conference without objection, August 7th, 2025, 9 a.m.
August 7th. Thank you, Your Honor.
Court calls case People versus Sean Newton.
Good morning, Your Honor. I don't have any body cam to prove it, but I am Lauren Brown, Deputy Chief Public Defender. Go ahead and state your name.
Sean Newcomb.
Thank you. Your Honor, we are on the verge of working this matter out. We do need to go ahead and submit a request for drug court, a referral for drug court.
Okay.
Oh, I'm sorry, no, I'm drug court. Yeah, actually, I'm confused. I need some body cam. No. We're gonna waive this matter over.
You're gonna waive?
I'm looking right at the waiver right now.
Sir, you're gonna waive your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir. I'm trying to plead guilty at circuit court and get out
Okay.
here.
That's too much information.
Bond reduction though, Your Honor.
Where I got.
Okay.
I'll do that.
So you understand that you will not have that hearing and you'll proceed to circuit court for further resolution?
Absolutely.
All right, people also waive their right.
You do, Your Honor.
Preliminary examination having been waived, been bound over to circuit court on the single count.
Yes, thank you, Your Honor. We acknowledge receipt of information, waivers reading in the record. My client was sending, actually, I think he needs to sign that waiver. I didn't know to sign it.
Defendant having waived former reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 30th at 1:30.
That's July 30th.
July 30th, 2025, 1:30, Judge Conlon.
Thank you. May we briefly address the issue of bond?
Yes.
Your Honor, my client's bond is currently set, I believe, at 10,000 cash or surety.
It's 5,000 personal recognizance. Unless he did something.
That got revoked, yeah.
What?
But obviously that was revoked because here he is.
What do you have as his bond?
Your Honor, if you recall, Mr. Newcomb had that incident with the saliva distributed amongst people.
Ah, yes. Yes, I do recall. Yeah. Go ahead.
Well, Your Honor, that was some time ago. The saliva has dried up and my client was coming off competency issues.
What?
He's coming off competency issues.
I got a lot of people that are coming off competency issues and don't spit in my courtroom.
Well, Your Honor,
On people.
he is very truly sorry for that. And he would like the court to know that.
I would like to
Again,
offer apologies myself, Your Honor. Did not mean it was very, very spur of the moment and reactive. I did not think that through. It was beyond my personal actions that I can really say would be something I would normally do. It was really, really odd for me to have done something like that.
Can we approach really quickly, Your Honor?
Why?
Well, if I say why, then I will need to approach.
I can just say no and it wouldn't matter, right? Yes, you may approach.
he's improved. And he's going through. So again, he was in court a few months back or several weeks back. He was going through some issues. Again, he's calm. He's much more even keeled. He's not that same guy. And I understand the contempt of court is something that the court takes seriously. I get that. He's ready to apologize and try to repair that aspect of it. What he's asking for the court is to see the person who stands before the court now, not the person who was here weeks ago, not that person, because he's not that person anymore. See the person who stands before the court now and allow him to have a return to a bond. It doesn't have to be a person bond. We'd be happy if the court would consider $1,000 cash or surety, but he's he's improved, and we want the court to see that.
At this juncture, what I'm going to do, and I mean, doing what you did that day put a lot of people in jeopardy, inconvenienced a lot of folks. We basically had to have I had to stop court, come in, clean up after you. Attorneys could not use the doorway. Your act, when it happened, clearly was intentional on your part. And bottom line is, I just don't tolerate it ever.
Yes, Your Honor, I completely understand that. And the people's reaction when it happened really floored me, and I realized what I had done immediately after I had done it. I wish I could take it back, and I know I cannot. And all I can do is offer my deepest apologies and pray for.
I am going to deny the request to reduce the defendant's bond at this time or change it. Maybe Judge Conlon, when he sees him, will feel differently, but I do not at this time. So his bond will continue. Thank you.
Thank you, Adam.
Is this all I have?
One other.
All right, court does call the case People versus Cortez Gray.
Have a nice wonderful.
I'd like to talk about hearing on behalf of Cortez Gray.
Your name?
Cortez Gray.
All right, what are we doing?
We would like to set this matter for a preliminary examination.
All discovery is complete.
Yes, to our knowledge.
People have their witnesses available the 29th. Preliminary examination, July 29th, 2025, 9 a.m. before Judge Barr. Bond continued.
Thank you, Your Honor.
Court calls case People versus Mariah Thomas.
Chairman, that is on behalf of Ms. Thomas. Ms. is not unmuted. Oh, there you go. Ms. Thomas, can you please state your name for the record?
Mariah Thomas.
Your Honor, we are going to be setting this matter for preliminary examination, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available to, well, we gotta need a writ on this, so the earliest I can get it in, not the 20th. What's the next one? Set her preliminary examination in person, August 5th, 2025, 9 a.m. before Judge Perry.
Thank you, Your Honor.
Thank you.
Thank you. Bond continued. Court does call the case of the People versus Samuel Peoples. Single cases. Everybody gets single cases.
Stephanie Can on behalf of Mr. Peoples, who is appearing to my right. Mr. Peoples, tell the court your name, okay?
Samuel Peoples.
Okay.
Thank you. Your Honor, we have a couple of things up today. We have a pretrial, and I'm sorry, I left my paper for this. As to the pretrial, I am going to ask that it be adjourned to try to come to a global resolution. Actually, I do not have one, Your Honor. I will provide one to the court shortly. So that we can come to a global resolution on this case. It's come to my attention today that they are thinking or considering potentially issuing out 2 more warrants that are sitting in the queue. These are all from events basically last year, all in 2024. And so I'm waiting for them all to come through so we can try and get a global resolution, Your Honor. So we're asking that the pretrials be adjourned for that purpose.
I mean, the probable cause.
Yeah, I'm sorry, the probable cause one, Your Honor.
And, Your Honor, it looks like, Mr. Peoples also has another PCC for next week's docket on a different case, so I didn't know.
Well, I guess if he's got another one, I don't mind, well, I do mind, but I would put it on for next Tuesday. But I don't know if that resolves what council's indicating because.
There are two warrants that I'm still reviewing. At this point, you don't need to hold up this process for those two warrants. That can be.
Well, I don't know that that's the case. I don't. Are they gonna be authorized? What's gonna happen with them?
So what I discussed with council, I just saw those last night. I thought that they had reviewed everything, but apparently they're still. But looking at what those warrants are, and some of the facts and the age of them, it's very likely that those will end up being part of a global resolution where we may agree not to authorize them anyway. So that's why I said they don't need to hold this up. But as for Mr. Peoples has a number of other cases that are charged, are authorized, but maybe misdemeanors, or he has a lot of other things out there. So I think that the overall global resolution will take care of those.
How much time?
I'm sorry, Your Honor.
How much time did you need to get that all together?
Your Honor, can we?
I would put this to the 22nd, but that doesn't make any sense. He'll appear on the 22nd. I just want to give enough time if you guys are going to try to put all of this together.
Your Honor, I am working very diligently as his prosecutor to try and reach this global resolution.
The two of you working diligently.
It's rare,
Yeah,
but it does
okay,
happen.
whatever.
And so I do have documentation from various doctors and everything that I need to provide to the prosecutor's office, which I will do likely today. Your Honor, if you want to just set it with the other PCC, that would satisfy.
5 days.
Or we could adjourn this one out to adjourn the one next week.
That's what I
Okay,
said
then we'll ask for
before.
more time, Your Honor. That would, yes, Your Honor, in your wisdom.
So why don't you do this? How much time are you gonna need to do all of this?
3 weeks. Your Honor, can we have 3 weeks?
So I will adjourn this to August 7th, 2025, 9 a.m. The first thing then you should prepare would be a step to adjourn the other PCC, which is set for the 22nd, to this same date.
And Your Honor, it will be done. Now, Your Honor, we're asking for bond modification at this time. Thank you, Your Honor. Your Honor, I'm asking that my client be allowed to be released in this matter. I don't think that the prosecutor's office, based on our conversation, is objecting to that release. My client was released from jail. He was in the middle of a psychosis. He was having some issues. The family was responding accordingly to the issues that he was having. Your Honor, my client was then voluntarily committed 2 days after the new case. He was just in the middle of his psychosis. During that time frame, his doctor, they went through a med review, they changed his medicines. And I believe he was there for more than a month on this, getting better. I've spoken to his doctor. I have documentation. Again, I'll provide it to the prosecutor. He now has a ACT. He works with the ACT team. He has an assisted outpatient treatment program. He has an open mental health case. They visit with him twice a day, making sure he's taking his meds. He is now on an injection.
If you file a bond motion or stipulation with his plan laid out, directing that he follow it, and the monetary amount of the bond, I'll consider it. But I mean, I'll let you go through, but I'm not, I can tell you I'm going to deny your motion right now because I don't have proof of, not that I don't believe you, but I don't have proof of anything that you.
Your Honor, I will gladly provide that to the court today. And both of the letters and all the information that I have regarding Mr. Peoples. I mean, so that you can have that, Your Honor, with the hope of getting him out. I will let the court know that he is not being properly medicated. The longer he is off of his meds, the unfortunate news for Mr. Peoples. You're fine, calm down. I'm gonna see you, you're fine. The unfortunate news for Mr. Peoples is he is on a litany of medicine, which I have provided to the jail with the pharmacy that he goes to, but they're not giving him his meds. I asked him this morning, he said he didn't have meds today. The And I understand, Your Honor, and I'm going to try very hard. I'm going to make sure I get you that information today so that the court has it today with the hope of like.
If the parties can agree to something with the plan that he's on laid out to the court, then I will strongly consider it. But
Thank you, Your Honor.
I don't have anything.
No, that's not a problem, Your Honor. I will get it to this court.
So motion for bond reduction, I guess technically at this point is denied. Bond will continue. Thank you.
Give me a couple hours. Okay.
Court does call the case People versus Taiwan Griggs.
Stephanie Cannon on behalf of Mr. Griggs, who should be appearing by Zoom.
Yeah, well,
There's that. Your Honor, my client, he was in jail because he came in on all of the bench warrants he had, because he had been in treatment, as the court knows, for so long. And he got out yesterday. When he got out, I didn't realize that. I went to jail to try and see him. Subsequently, I have reached out to see if he would talk to me or if I could find him, Your Honor. My client has appeared for every single appearance. I believe this is just a case of.
but wasn't he in custody?
He got. Yeah, I went to see him yesterday.
Provided the transportation, so of course he was here.
Yes, Your Honor.
Okay.
But Mr. Judge, hear me out on Mr. Griggs. So Mr. Griggs has been in mental health treatment and in substance abuse treatment. He had these open warrants that he had to turn himself in on. He does turn himself in on it. He is able to get bonded out. I just don't know that normally I call him and we have a conversation, Your Honor. This case has been up several times and the court is aware that he has been here every single time. He's never missed. Your Honor, how about this? If I can get him on Zoom, will you allow that?
Oh, were you done?
Yeah, I'm done, Your Honor. I'm just, sending good vibes your way.
Bench warrant will issue for defendant's failure to appear.
Thank you, Your Honor.
Bond will be set in the amount of 10,000 cash or share. Will not issue that warrant until Monday. So you can go try to find your client.
I will, Your Honor. Thank you.
Court does call the case People versus Jalen Priester. Yeah, I think I saw the text, but I don't know what time she needed me by, but I haven't, I responded back.
Good morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
And Kerma Dadush on behalf of Mr. Priester, can you please state your name for the record?
Jalen Priester.
Your Honor, we've just received discovery. We were going to ask for an adjournment to review that and a moment to address bond, please.
What was the last thing you said?
And a moment to address bond, please. If you'll allow it.
You don't really want my answer. Probable cause conference will be adjourned July 31st, 2025, 9 a.m. As to bond.
Thank you, Your Honor. We're going to be asking for a reduction on his bond. Mr. Priester has a full-time job at the University of Michigan Building Services. He is able to go back and stay at his father's address if he is released. He is able to get released on, if Your Honor would agree to his release, he can be on a hot zone tether, as I believe the magistrate had ordered that if he were to be released. I don't believe he has any other cases holding him.
He does not?
I don't believe he does.
Okay.
And he just wants to be able to go back so he's able to not lose his job that he has. So for those reasons, we're going to be asking for a personal recognizance, Your Honor.
Memorial Day of this year, 3:00 in the middle of the afternoon, Mr. Priester and a buddy of his thought it was appropriate to go shooting through an apartment complex parking lot. One witness that he was apparently trying to get says that she has received death threats via text from him and his buddies, as well as they tried to run her off the road. 2 other innocent bystanders had bullets ringing through their apartments. One in particular was laying in the bed trying to take a nap at 3:00, and she was woken up by the bullets coming through her window entering into her bathroom. He has currently a $35,000 cash surety bond. He is only 22 years old. With this type of activity, I would certainly oppose any type of bond modification.
Well, Your Honor, if he is put on a home confinement tether with the ability to go back to work, that would perhaps ensure that he does not go anywhere that he's not supposed to be going, or do something that he's not supposed to be doing.
The unloading of a firearm, which are the allegations at dwellings where people are. I'm quite frankly shocked that his bond is so low. I'll be absolutely honest with you. And so if I were to receive a motion from the people, I would raise his bond. I am certainly under these circumstances not going to reduce his bond.
Understood.
Defendant's motion for bond reduction is denied.
Understood. Thank you, Your Honor.
Court calls case People versus Suzette Hampton.
And on behalf of the people, Your Honor.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Hampton, who's approaching. Judge, state your name, ma'am.
Suzette Hampton.
Thank you, Ms. Hampton. All right.
Your Honor, we're asking to adjourn this matter to, I want to go over the video discovery with Ms. Hampton, and Ms. Londi and I have actually talked about possible resolutions.
All right. Probable cause conference, August 7th, 2025, 9 a.m. On continue. Thank you.
Thank you, Your Honor.
Court does call the case of the People versus Hampton.
Stephanie Cannon on behalf of Mr. Turner. Mr. Turner, could you state your name for the record?
Anthony Sherrod Turner.
Thank you.
And Your Honor, we are going to ask for an adjournment of this matter. We're trying to get an offer. My client has been accepted into mental health court. I have been working.
He has been?
Yes, Your Honor, he has.
Okay.
He's been accepted. I have the paperwork here, but I don't have the misdemeanor yet that would allow him to go. So while everything is filled out, I can't do anything until I negotiate this down to the misdemeanor. I thought we were on that, Attorney Childers and I. However, he's not here today, and
July 31st, 2025, 9 a.m.
say the words July 31st. Your Honor, can we address bond in the meantime?
Go ahead.
Your Honor, I would ask that my client be allowed to be released. You can tether him. He has a place to live. He's been in there for quite some time. It is my belief that this will go down to hopefully, with his being put in mental health court, go down to a misdemeanor. And he has already met with the mental health court people. My client is super excited about it. When I met with him on Monday, he talked about it quite a bit. He likes the mental health court staff. And if the court wants, he'll even go to the next mental health court session to start this process.
Response from the people.
Well, other than the court's discretion, it doesn't appear that there is any significant history, and it doesn't even look like we had a cash and surety request at arraignment, so I don't.
No, he was on a PR, didn't appear, and then it was a while, we finally got him back. And then started heading down this court. But where would the defendant be residing?
Could you give him your address, Mr. Turner?
312 West Huron.
Sign your name.
In Ann Arbor?
Ann Arbor.
Yeah. At this point, why don't we get the plea and everything worked out? Once he's out of his court, that court can decide, but at this point, reductions.
Thank you so much, Ron.
Do what we gotta do. Court calls the case People versus Ardashir Hassani.
Good morning, Your Honor. Assistant Prosecutor appearing on behalf of the people.
Malika Fatima appearing on behalf of Ardashir Hassani.
All right, your name, sir?
Ardashir Hassani.
Thank you.
Your Honor, at this time, we are requesting for an adjournment.
Okay. Would you be able to accomplish your task by the 7th, or did you need one more week out? You have no idea, do you? All right, I'll just make the call. Probable cause conference, August 14th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Okay, here we go. Court does call the case of the people versus Daniel Magoo.
Good morning, Your Honor. Ashley Lottie for the people.
Sir, state your name.
I'm here on a special appearance, Your Honor. Magoo is Easy Elastical Trust, registered in Jackson County, on case number 2522246.
Okay, is your name Daniel Magoo?
Your Honor, that is the name you seek, and it is copyrighted and trademarked.
Okay, very well. Mr. Magoo, are you represented by an attorney, or do you wish to be represented by an attorney on these matters?
I am not.
Do you wish to be?
No, not at this time.
Let me then do this. You have two cases before this court, one being the case ending, well, let me get the full case number 25F40523. In that case, sir, the complaint does allege that on March 27, 2004, you committed the offense of operating while intoxicated. Do you understand what you're charged with?
I do not.
You do not understand
There is
that?
no eyewitnesses or corroborating witnesses at all.
I'm not asking whether or not the proofs are there. Do you understand what you are charged with?
I do not.
Do you understand the notion of drunk driving?
I do not understand how I could be charged with something without a
On
witness.
your other cases when you represent yourself, so we'll just do it.
You're talking about the case that's in federal court right now,
You
Your
are
Honor?
before a complaint in that case for a charge of operating while intoxicated, third offense. Because it's a third offense, that is a felony. It is punishable by up to $500 to $5,000, up 1 to 5 years incarceration. The court can order probation, 30 days to 1 year in jail, or at least 48 hours must be conserved consecutively. The court can also order community service, rehabilitative programs. The court can also order your vehicle immobilized, can order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services.
As I am here and as a trust, Your Honor, I am here in exclusive equity.
You count 2 on that complaint is the charge of operating while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs, and your vehicle could be subject to immobilization.
My license is canceled, not suspended or revoked. It is canceled through the state of Michigan.
Complaint
Canceled.
Is the charge of escape from lawful custody. That is a misdemeanor punishable by up to 1 year, a $1,000 fine.
I was never arrested or read any Miranda rights accordingly.
Given that the defendant is talking in English, that he understands English, understands the nature of those charges and what he's charged against.
So malicious prosecution by Washtenaw County prosecutor as usual.
Sir, there is great peril in representing yourself. You will be held to the same standards as anybody apply or.
This is a matter under the Eastern District of Michigan Federal Court. Case number 2511226.
We're not represented by counsel. I would further indicate, sir, that at any point during these proceedings, if you wish to be represented by counsel, you can make that request to the court and counsel would be appointed to represent you. Because of the defendant's conduct in the past in not acknowledging the court and what the court is saying, the court does make the presumption that he does speak English. He understands that. I would further state on the record that Mr. Magoo has been through this process before. He does understand that if he does wish to be represented by counsel, the court would give him counsel or would have counsel appointed to represent him in this matter. In the case 25F309,
0979. In that case, sir, you are before a complaint that alleges that on or about July 3rd of 2025, count one is fleeing and eluding fourth degree.
Added on by the
Police
prosecutor's
officer.
office after the
Sir,
fact.
that is a felony, punishable by up
Malicious
to 2 years
prosecution.
incarceration and a $2,000 fine plus court costs, mandatory suspension by the Secretary of State.
My Secretary of
two
State, anything
is
is canceled. I have no contracts with the state of
Vehicle,
Michigan.
that is a misdemeanor.
This
Charge
is a matter of trust, Your Honor. This is a matter of trust. I am protected
to
under a
90
trust.
days in jail, a $100 fine plus court cost. Count three on that complaint alleges operating a motor vehicle without security. That is a misdemeanor, not punishable by not more than 1 year incarceration and not less than $200 nor $500 fine plus court cost. Count four is operating while licensed, suspended, denied, and or revoked. That is a misdemeanor.
All of my registrations are through the federal government. I have federal government registration. I do not have contracts with the
Vehicle could
state.
be subject to mobilization. Count five on that complaint alleges refusal to obey refusal to.
I have an international driver's
Police
permit.
officer. That is a misdemeanor, punishable by up to 90 days, $100 fine plus court cost. I would indicate to the defendant the same admonishments regarding the perils in representing oneself that I stated in the other case also apply to this case.
Were you served your notice and summons yet, Your Honor?
Wishes to have counsel appointed. The court would consider or would appoint counsel to represent him in this matter, and he apparently wishes to proceed.
Were you served your notice
Having
and summons
notice
for federal
of
court?
the charges, sir, do you wish to still proceed without an attorney?
I just want to know, where do you get
Do
your
you
powers?
wish
Are
to
you an Article
proceed?
3 judge or an Article 6 judge? Where are
Do
your
you
vested
wish to
powers? Can you
proceed
answer
without
that?
an attorney?
You can't even answer
look
me
it
what your
up.
powers are.
You can look it up.
No, you guys disconnected my access to any kind of law library or anything. You are an Article 6 judge under the Michigan Constitution. You have no authority to deprive me of my
We'll
rights.
see how much authority I have. I will assume that you wish
This is
to
a matter
proceed
of
without
trust.
counsel. I will assume you wish to proceed without counsel and that you will wish to continue to proceed.
Practicing law from the
To
bench.
inform the court otherwise. Ms. Lundy.
Thank you, Your Honor. Is the court completed the arraignment for the record at this time? on both
Well,
cases?
he had been arraigned. I was just admonishing him of the perils of representing himself and that it requires in part that I let him know what he is charged with. And I've read them kind of in fully, more so than I would have because he refuses to acknowledge those. So I am satisfied that he now knows all of the charges that are against him.
Thank you, Your Honor. The people would like to be heard on bond when appropriate.
All right. What do we want to set this for? Do you wish to have a preliminary examination, sir?
This is a matter of a federal matter now, Your Honor, under case number 2511226, under the Eastern District of Michigan, under the Honorable Mark A. Goldsmith and Magistrate Judge David R. Grand. There is no proceeding here, Your Honor.
There is no proceeding. Oh, there's a proceeding.
Well, malicious prosecution is what the proceeding is.
Okay, very good. Do you wish to have a preliminary examination?
There's no proceeding, Your Honor. This is a matter that should be stayed and
What is
dismissed.
the people's position on whether or not we should set this for a preliminary examination or adjourn the probable cause?
Your Honor, I don't know if the defendant has received all discovery in this matter as he is representing himself, so I would request a probable cause date, potentially.
Because you've got to send it.
Yeah, and who restricted my phone
Probable cause
calls?
Conference, you know what? You're gonna have to stop interrupting. I will give you an opportunity. You've been before me before. I will give you an opportunity to say whatever you want to say. But I'm not gonna have you interrupt me and I'm not gonna have you interrupt people when they're talking. As long as you were saying.
Thank you, Your Honor. I have to there's video evidence in addition to the paper discovery. I've got to make arrangements with Lieutenant Arnett to work on that. So it may take just a bit longer. I would potentially look at the 7th, maybe, if the court would have entertained that. And then I will wait to be heard on bond when the time is appropriate.
I will adjourn the probable cause August 7th, 2025, 9 a.m. As to bond.
Your Honor, I've been reviewing ex-jail and I wanted to double check if the defendant has been arraigned. It's not clear to me from a couple of different things, but it does appear that he has been set with a $10,000 bond in 25 F 30979. as well as 25 L40523, each $10,000.
Yes.
Your Honor, I do think it's important that the court have some additional information, and I would have to ask the court to revisit the issue of bond. First and foremost, I think it's important the court know that the facts alleged in the newest case, the 25 F30979, it does include the fact that the Michigan State trooper who pulled the defendant over noted in his police report that the defendant had a license on his vehicle that indicated he was a diplomat and that he refused to identify himself. He refused for quite a bit of time. Additional units had to be brought to the scene from the sheriff's department in order to, for lack of a better term, deal with the situation. And ultimately, they were able to identify him as the defendant, Daniel Magoo. The concern with that goes along with the other case, which is an OWI. It is charged as a third. I will note that it is a true fourth, to the best of my understanding. So there does appear to be an alcohol problem going on. And I also think it's important for this court to know, because I don't know that the court knows, the defendant has a third new case, telecommunications malicious use with a domestic relationship, that is currently pending as well. He's also been set $10,000, 10% in that matter. But I think
Where is that case out of?
that case is out of 14B, Your Honor, before Judge Washington.
A co-defendants with the federal case that you guys are both in, and this is a conflict of interest as both of you guys are defendants in my federal case.
Go ahead.
I also understand, Your Honor, that there is a municipal case out of Canton Township that was set for a jury trial in April of this year, where the defendant failed to appear. And there were jurors, there was a veneer that had been brought in. And I bring all of this up to say, Your Honor, that the people are concerned about the defendant's ability to remain law-abiding, because I'll also note for the record that at the time that the new resisting, obstructing, fleeing, eluding case and the telecommunications malicious use case came up, he was in bench warrant status before Judge Slay, is my understanding, for refusing to come after the case here had been found over, refusing to appear in person. I say all of that to say this: I do think that $10,000 is too low. And I also am going to request a SRAM tether, because this is an OWI fourth alleged, as well as a GPS tether, given his history of failure to appear and failure to comply with court regulations. Thank you, Your Honor.
Is the bench warrant before Judge Slay still out?
She has bond denied in her case now.
His bond's been denied in that?
Yes, that's correct, Your Honor.
Got it. Anything you'd like to say?
Anything to do with any contracts with the state of Michigan are void ab initio for a matter of law, as I have an canceled driver's license and I have an international driver's permit. And that also relates to the Canton case that they're trying to stick me for a driving unlicensed suspended citation, in which that I have an international driver's permit, making it also void. All of my matters, including the vehicle that I'm registered under, are registered to the federal government, not the state, under the Federal Motor Carrier Safety Administration. All of these charges are frivolous and a part of a long pattern of malicious prosecution by Ms. Londy, the Washtenaw County Prosecutor's Office, and quite frankly, you, Your Honor.
Hearing argument regarding bond, the court does believe that it was an abuse of discretion, given the circumstances of this defendant, to set his bond at the $10,000 figure. After hearing argument, viewing the file, the court does believe that not only does the defendant pose a risk to the public,
no victims,
believe that the defendant is a risk of flight given those circumstances, and has indeed, or at least is charged in this case, refused to obey or fled and eluded.
That was added on afterwards. The police officer did not report that at all.
The court, given those circumstances, would in each case raise the defendant's bond, grant the people's motion. Defendant's bond in each matter is set in the amount of $50,000 cash here. Thank you.
The tethers I requested, if he is able to post, Your Honor.
I will.
Thank you.
Thank you.
If everybody doesn't mind, the court's gonna take a very brief recess, and then I will come back and we will finish them.
All right.
James Jameson, 25GA2767.
Good morning, Your Honor. Member Zelenak, hearing for the defendant. Step forward, and I'm going to have Mr. Hinman take a seat here because he's the PR of the estate of the home that's the subject property, just so the court knows we're not stringing it along.
Okay, that's fine.
Give your name.
All right, so this is a nuisance charge. There's repairs that have to be done. Is that right?
Yes, sir.
Mr. Zelenak, is that?
That's correct, Your Honor. We have a conflict today. Got a very tough prosecutor today. Won't make any offers, so I have to get.
Oh,
I mean, there's a conflict with the prosecutor.
you know what? I think we're just gonna go ahead. I'm not even gonna arraign today, okay?
All right, that's right. Sergeant Robinson signed the form.
Yeah, I know, but let's just reschedule and just make sure that, Mr. Bologna is here next time, okay? We'll just give you a couple of weeks, but he's already been here once, right? I adjourned it to
We
today.
adjourned it because I mistakenly thought it was a civil infraction and told him I would handle it. So you put it over already, and
He said, you know, the ticket was issued. I hope he's gonna get going. The ticket was issued May 27th.
yes,
You gonna get moving, young man?
it's in an estate, Your Honor. He was the co-owner on the deed. His father passed away. The house has never been occupied, and he's pulled all the permits, but Mr. Hinman now is the personal rep of the estate. They're gonna make sure they hire the right contractor.
All right, let's adjourn it. We'll give him 4 weeks, Lisa. You got August what, 15th?
August 14th at 8:30.
That's a Thursday, right?
Yeah.
Yes.
Okay, August 14th,
We need to
8:30.
bring the PR back, or do we, I think he's seen enough courts for his life.
No, this is the named defendant. He can,
We were just, Judge, I know that lawyers that want to provide the court with deviations from the truth. I just wanted you to believe that I was telling the truth.
you're fine.
Thank you, Your Honor.
Take care, thanks. Good luck, sir. Congratulations, Mr. Hinman.
Have a good day.
Well, how many years were you there?
45.
You needed to go 5 more. They could have
Yeah.
given you a gold coin or something.
You'll be back. You know, Your Honor, some of the people you put in jail are just getting out too, so.
All right. People against. Knighton, Solomon Wesley Knighton, 25F2589441.
Good morning, Judge. We have to see on behalf of Mr. Knight, state your phone number.
Solomon Wesley Knighton.
Okay, so Mr. Knighton here. So it says the prosecutor subpoenaed the victim. Victim failed to appear. Victim took a plea as the aggressor. Moving to dismiss. Case dismissed. Lisa, make sure you take out, I'm gonna find that stamp, but we gotta take out any bond conditions on this, okay? You're all set. Good luck.
Thank you, Judge.
Thanks a lot. Chandler. Brandon Scott Chandler, file 25T645681. Morning, sir. Your name?
Brandon Chandler.
You're charged with driving on a suspended license. I can arraign you and let you go talk to the prosecutor, or I'll give you a lawyer, whatever you prefer.
I'm not really sure. I should ask my mother.
If you're in doubt, get a lawyer. Let's give you a lawyer, okay? Go get the lawyer out in the hallway. You'll talk to the lawyer. The lawyer will talk to the prosecutor, and then you'll come in, okay? All right, with the lawyer, thanks. Is there anything else down there? This is moving like a snail.
There's the no-shows from yesterday.
Yeah, let's do them. Matthew Glenn Malone, 25B148976. Mr. Malone failed to appear yesterday. We're going to issue a show cause against Brianna Ray Barnier, 25B148694 A and B. On the A file, defendant failed to appear yesterday. We're going to issue a show cause, and on the B file, same thing. Show cause to issue on both of those for failure to appear. Marlon Amir Owens, 25B149007 A and B. This is indecent exposure, telephone harassment. Defendant failed to appear yesterday for arraignment pretrial. We're going to issue a show cause for requirements of the statute. Jordan Cornelius Adkins, 25B147641 A and B. On the B file, defendant failed to appear yesterday. That's a civil infraction default judgment. And on the other file, warrant issued, about his third miss, 5,000, 10%. And by the way, for the record, the default judgment it entered back on March the 26th. I don't know. So now 5,000, 10% isn't enough. He's had enough misses. 7,500, 10%. People against BSC Investment, 24B147019. Mr. Butler failed to appear. We issued a show cause. This is 24B147019, BSC Investment. They failed to appear February 3rd. And then we issued a show cause versus the company. And we are going to issue a warrant because we show caused Mr. Butler, the president or owner, bench warrant to issue versus Kenneth Butler. I think you should give a call over there, Lisa, or I will have Tabitha 353 cash or surety. Tell them a warrant's been issued for the arrest of that individual. Jackson, Jalen Keyshawn Jackson, 25B148633 A, B, and C. On the A file, and failed to appear, also failing to appear before. 3,000, 10%, warrant to issue, bond to be forfeited, and on the B and C files, the defendant was already defaulted on those civil infractions back on June the 18th. Bryant Allen Kinney III, 25B148464, defendant failed to appear. This is a indecent exposure charge, 4,000, 10%. Failed to appear for show cause before, and then failed to appear today. Warrant to issue, 4,000, 10% will be the bond amount. Matthew Glenn Malone, 25B148493, defendant failed to appear. 3,000, 10%. Frank Joseph Renna, 25B148513 A, B, and C. On the B file, I'm going to issue a warrant, 3,000, 10% on the, that's for the second miss. On the A file, 2,000, 10%. And on the C file, a default judgment was already entered on July the 2nd. Antoine Leishon Torrance, 25B148-681 A and B. 3,000, 10% on the A file. On the B file, the defendant was already defaulted when he failed to appear for the first hearing on July the 2nd. Anything else? I'm sorry? Nichols, Lolita Marie Nichols, 25T6458898A and B. Your name, ma'am?
Lolita Marie Nichols.
You charged with driving on a suspended and disobeyed traffic signal. If you want a lawyer, I'll give you one.
No.
Okay, so I'll go ahead and arraign you then,
Yes.
and then I'll enter a not guilty plea, and I'll let you go talk to the prosecutor. Is that fair?
No, I'm guilty.
No, you don't need to do that. Just relax. Let me go ahead and arraign you,
Okay.
and then you go talk to the prosecutor, okay?
Okay.
All right. On June 25 at 8:25 in the morning, the police think you were operating a motor vehicle on 4th northbound with Harrison and Trenton. They think you had a suspended license that is a misdemeanor, punishable by up to 500 fines, 93 days jail. Costs are all of those in 2 points. They also think that you disobeyed a traffic signal. That's a 3-point civil infraction. You understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
I agree.
Okay, do you still wish to waive your right to a lawyer?
Yes.
I'm gonna enter a not guilty plea. I'm gonna enter a plea of denial. I'm gonna give you a $500 personal bond. Here are your bond conditions. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. I'm gonna send you right to the prosecutor, and you go talk to, is that Ms. Zelnick? Go talk to her today. I think it's Ms. Zelnick, and then you'll come back in front of me, okay?
All right.
And if they don't give you what you want, you tell me and I'll give you a lawyer, all right? Good luck. Anything else ready out there? Can we see if Mr. Gates can come in here with a couple anyway, get a
I
couple?
will. And I've got to come and run his file down.
Jessica, what are you here on? Ms. Wilds, what are you here on?
We're just here watching, Your Honor, so we know what comes out of the courtroom, because you're not live on YouTube today.
You should be live streamed.
Oh. Okay.
Jessica, can you check again?
Yes, I will check right now.
Thank you.
Oh, you're on live now, Tabitha.
Thank you.
All right, great. Well, I'll log out now. Thank you.
If you want to stay there, if it's going to help you, I don't have a problem. I mean,
No, it's all right. Since you're live on YouTube, I can see everything now.
okay, all right.
Thanks, Judge.
How you doing, Mr. Zolman?
Your Honor, I'm doing well. I found out that I could have went to Miss Foley and had her signed off and arraign that fellow, but I appreciate your courtesies.
No problem.
It's nice to get Mr. Hinman out. He didn't tell anyone he was retiring. He just left.
Wow,
45 years.
that's something else. Now, he's not a lawyer, is he?
No, he did all that, all those years ago.
Wow,
I just think,
good for him.
yeah. And he got engineered that beautiful courthouse. He
Yeah, it is beautiful, isn't it?
did an incredible job. I have two.
Do you know that that one was patterned after this, not this one that they built, but the old one was patterned just after this.
Exactly.
Because my dad and Jim Stone were very good friends. And my dad built this and Judge Stone kind of copied it. And they were basically the same courtrooms, except that they expanded before we did. You know, they expanded when I was still a lawyer. And then, I don't remember if they had 3 judges back then or not, or when they got 3. But anyway, yeah, that's a beautiful place.
Now they're paying for it.
What's that?
They're paying for it now. They built it at the right time, but you couldn't afford to build that type of facility these days.
No.
Not at all. The tariffs and everything, it could never.
It's crazy. How you doing, Ms. Caballero?
Things are getting better.
Good.
How are you?
Doing all right. Caitlin, do you have anything else in there for me?
I just carried two in for.
Oh, okay.
That's it for now, Your Honor.
Okay, if I don't have anything else, I'm gonna get off the bench here after I take Mr. Zolnick's.
No.
People against HSI Trucking, 25B148-597A and B.
Good morning, Your Honor. Edward Zelenak, hearing for the defendant respondent. It's a corporation. I have authority to enter into the pleas. I called Ms. Foley yesterday to ask if she'd like the corporate rep here. Yes, there are two driving offenses involving a trucking company. She indicated she was going to offer civil infractions to resolve it. If that's, with your approval, we'll actually waive the reading on the.
I'll enter an not guilty plea on file A, that's the misdemeanor, and then there's going to be a plea to distracted driving and overweight. Overheight, I'm sorry, overheight. So, and you're authorized to enter these pleas on behalf of the company?
We're allowed me to plead responsible with the two counts, distracted driving and overheight, Your Honor. The scrap metal on the top of the truck, and apparently the man doesn't measure well. It was a 14-foot height, and it hit a 13.5-foot width.
Oh, no. All right.
Damage to the bridge, that's the good news, Your Honor.
Okay, so to the charge distracted driving on file A, you plead responsible?
Responsible, Your Honor.
And on file B, to the charge of overheight, responsible?
Yes, Your Honor.
Okay, I'll accept the pleas. There can be, so I'm going to charge, in accordance with our schedule, $235 on the overheight. I'm sorry, $235. And then we'll give them until August the 15th to pay. And the distracted driving, $250, and pay that by August the 15th, okay?
Yes, Your Honor. I'm going to tell them it has to be paid by the end of the week, because corporations are worse than individuals sometimes.
Okay.
I'll let them know it's going to be paid by Friday. Thank you, Your Honor.
Have a good day. Thanks.
Thanks for everything.
Here.
We were just stragglers.
What is this?
Let's go inside the file.
Haywood Trucking Company?
It's time coming down.
So I have 25B14873O A and B. All right, sir, how you doing? You can have a seat. You sure?
Yes.
And what is your name?
Aaron Haywood.
Are you the principal of the company?
Yes.
You're the president?
Yes, sir.
And you're authorized to enter these pleas on behalf of the company, right?
Yes.
So you're going to plead to overweight with agreed upon fines and costs of $1,000. They're going to dismiss the safety equipment charge, right?
Yes.
Okay. So on behalf of the company, to overweight, responsible or not responsible?
Responsible.
I'll accept the plea. Dismiss the safety equipment charge, $1,000 your total. How much time do you need?
Next Friday.
Okay, I could give you a little more than that. I'll just make it August 15th. If you can pay next Friday, great. If you can't, you have till August 15th, okay?
Okay, thank you.
Best of luck. Good luck with, hope you heal well, whatever happened there. Good luck.
Okay, I have a question. Now, is it a website I can pay?
Yeah, you can go right on 33court.com. They'll explain it to you down the hall, but you're basically going to go on there, 33court.com, with your case number. And for the record, this would be the file A, not B. Okay?
Okay, thank you.
Lisa, is there anything else you need to tell them on that? Not really, right?
No.
So just 33court.com, and then you make sure you put in the right case number. That's the A file, not the B file, okay?
All right, have a good day.
You too, good luck. Mr. Dillon, did you talk to the prosecutor
Go
yet?
into a breakout room, Judge.
Oh, okay.
Sorry, Judge, I was going to a breakout room.
No, that's okay. Go ahead. And then when you're ready, I'm going to get off of here for a couple minutes. It's been slower than molasses. I don't have hardly anything coming in. I'll be out as soon as you get yours done though, okay?
Thanks, Judge.
Hey, Will,
Yes.
at 10 o'clock, Gonzalez Corona, there is an interpreter coming at 10.
Okay, thank you. And I have Braden Hunt here too. See you, sir.
Yes, sir.
It's a civil matter or something. Braden Hunt.
Got it.
All good or not? All right, what do I need to do? You good? You know what's happening?
You do something at home?
Yeah. All he says is just go down to court. They don't go down that is.
Well,
And I went out there and countered that. And like,
well, he's
most of it, Lawrence. Yeah, case, I'll just get it. Okay, here's you. They'll bring me your file. I need 3 sentencing. Okay. All right, what are those? Because he did show no shows, right?
so we did yesterday.
Just right here. Yeah. He shot the shuffle. Time to pay.
Yeah, these are. Thank you. Yeah, these are yesterday.
On screen.
Responsible. I'll accept the plea, $1,200, pay by August 15th. Is that the only one you have?
Yeah, that's it, Your Honor.
Thank you. Have a good day.
Thanks, Judge.
Gonzalez.
Appreciate it.
Sonia Adalia Gonzalez Corona, file 25B148788A. Good morning.
Good morning, Your Honor.
Your appearance?
That was, they were all certified court interpreter.
Okay, nice to have you here.
Thank you, Your Honor.
I'm going to ask you to raise your right hand. You solemnly swear or affirm that you'll make a true and accurate translation between the court and the defendant.
Yes, I do.
Can you tell me your name, please, ma'am?
¿Y usted, señora, puede por favor dejarme saber su nombre? Sonia Italia González Corona. Sonia Italia González Corona.
You are charged with violation of instructional permit.
Que usted han acusado de que hubo una violación del permiso de conducir. Sí.
You have the right to a lawyer.
Usted tiene derecho de tener un abogado.
I'll be happy to give you one today.
Y yo con mucho gusto que le daré un abogado de justicia.
Would you like a lawyer
¿Y
to represent you?
para representarla a usted? Do I need one?
It's up to you. You probably should get one.
Probablemente usted debería tenerlo. Okay.
I'm not saying you're going to jail or anything, but they can certainly help you.
No estoy diciendo que usted la voy a mandar a la cárcel o algo semejante, pero no puedo ver eso puede ayudar.
Okay?
I agree then.
So we'll send you to a lawyer, and either way, you're coming back in front of me, okay?
La vamos a mandar, que tengan una poder y el otro
Thank you.
Yeah.
Thanks.
You're right.
Rana Group LLC, 25B82635, 25B82613, 25B82612. What is your name, ma'am?
Rana Matar.
Nice and loud.
Rana Matar.
What is your position with that company?
Landlord resident.
Okay, so let me explain something to you. Corporations really need a lawyer, okay? This is a corporation. I have no issue with you pre-trying this or having a pre-formal hearing on this, but if you're gonna contest it, I really have to have you get a lawyer, okay?
I didn't know what I need to do.
Well, it's a corporation, and technically I can't allow you to engage in the unauthorized practice of law. Not technically, I just can't. So I don't have a problem on a civil infraction, underline that. I don't have a problem allowing the president to appear and work it out, but if you can't work it out and it's a contested hearing, I can't really let you practice law here. So you're gonna have a lawyer. I'll schedule it for a formal hearing, but you have to get a lawyer, okay?
Okay.
All right, Lisa, set formal, and you're gonna have to move quick, okay? Set formal for,
August 13th at 9:00.
I don't have a docket on any of these until then, huh?
Well, you do. It's just less than 2 weeks.
All right, August 13th at 9:00, okay, ma'am?
Okay.
Any questions? Any questions?
I was asking her,
Who?
what, Caitlin?
Yeah,
What are the fees that she would be telling me anything?
well, this isn't a payable misdemeanor. These are rental registration. You have to have your rental property registered with the township.
And I tried,
Well,
there's
they've had-
something happened there, the right hand of the door, the left hand is doing, and
Well, you can get your lawyer to, I just,
I know, I was always asking her, I'm sorry, I don't want to waste the time.
you're not worried, you're not wasting my time. This is what I do.
Okay.
This is what we're here for.
Okay.
But you have to have your rental property registered, and it looks like you haven't been successful in that. Okay?
Well, this is their story, right?
Well, I'm not saying they're right.
Yeah.
I'm not saying any of
That's
that.
what I'm saying, that's their story. They're paying out, but they don't want to do the inspection for $10. It's a story that we need to hear for.
The one of these citations said it failed on
Yes, and they will not come to re-inspect
multiple failed inspections,
because they couldn't go in. The tenant will not open the door. That I don't have a tenant there anymore, so they can go.
Better get a lawyer, okay? I mean, if you guys want to go in, if you want to go in and talk to her again and see if you can resolve it, that's fine. I'm gonna be here all day, so if you want to go in and talk to her, feel free.
To the city?
No, to the prosecutor.
Where you were in the jury room.
Yeah, but she said we can't resolve, get this resolution. And that's what I don't understand. There's something I'm missing here.
I don't know what to tell you. It says multiple failed inspections, so they must have been out there. They wouldn't write that on a ticket, I don't think.
They couldn't go in. Yeah. I'm trying to talk to her again, but she said we can resolve it, so you probably want to get here.
Okay, well, that's what I'm scheduling it for, but if you go back and talk to her and you guys resolve it, she can bring the files back in, okay? Thank you. Kenneth Marcel Morast, 25F244203. Wow. How you doing?
I'm good, how about you?
Good. What's your name?
Kenneth Morast.
You know why I said wow?
Yeah.
What do you think? Because I actually have somebody that was told to come in and pay, if they couldn't pay, to talk to us on or before the due date, and you're doing it. Congratulations. I'm gonna have you, we're gonna put you on TV with a Wheaties box and everything else behind you. How much time you need?
2 weeks.
To pay it all, or do you need more time?
Pay it all.
You sure?
Yes.
Where do you work?
I don't work. I play basketball.
Play basketball for who?
McLennan, it's in Texas.
Texas?
Yes.
How old are you?
20.
Next time come to court without the gun, okay? Can you pay by July 31?
Yes, that's fine.
What, is that a college?
Yes.
Yeah, what do you play?
Basketball.
Oh, okay, good. What position though, I meant?
Oh, point guard. I was in Idaho last year. I was a redshirt freshman.
And so you transferred over?
Yeah.
We're gonna see you on TV someday. Good luck.
Thank you.
If you need more time, you can just call in on Zoom. I'll be glad to give you an extension, okay? Lolita Marie Nichols, 25T645-898. A and B. Could I have Quentin Clanton seated at the table, my right, your left? Ma'am, your name?
Lolita Marie Nichols.
Did you talk to a lawyer?
I talked to the prosecutor, yes.
Okay, you talked to the prosecutor. We're gonna adjourn this. You wanna talk to a lawyer, it says, wishes to speak to an attorney? Okay, so we're gonna give you a new date. It's July 31, Lisa, or no?
Yes, 10 o'clock.
10 o'clock.
Yes.
July 31 at 10 a.m., all right? Go down the hall, we'll give you your notice, any questions. Good luck. Quentin Antoine Clanton, 25G306486. Your name? You're charged with compulsory attendance at school. What time did you show up this morning?
30 minutes ago.
How many?
30 minutes ago.
That'd be 9:45, about, right? We were scheduled for 8:40.
I couldn't find my, I misplaced my paper. I found the old.
Listen, what would you think of me if I came in here at 9:45?
You're responsible.
Thank you. Gosh, this is just a beautiful day today. You're charged with compulsory attendance at public school. You want a lawyer?
No.
You sure? It was alleged that on April 14 of 25 that you had a child going to Carlson High School at 30550 West Jefferson in Gibraltar, 12 p.m., and that you failed to require the child to go to school, basically a violation of parental responsibility law. That is a misdemeanor, punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes.
You just sign, read, and understand the advice of rights.
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
You still wish to waive your right to a lawyer.
Yes.
Not guilty, pleas entered. You're to make sure that the child goes to school with no unexcused absences. Deceased child to go to school, to attend school with no unexcused absences. Okay, I'm going to send you back to the prosecutor. You speak with them, see what you can resolve. Did you graduate?
No, I got a GED.
All right, we need to make sure kids, how old are you?
I'm 42.
Yeah, see, 25 years ago, you could get a job with a GED. It's going to get to the point where you're almost going to need a law degree to get a job at McDonald's. So you got to get that child to school, okay? Go talk to the prosecutor. Come on back. Good luck. Tamika Denise Brown, 25B146816. A, B, and C, and 19B1358135871. A and B. Who's your lawyer, ma'am?
I cannot remember his name.
Was it Mr. Gates?
I think it was Tony. With the Brownstown case.
Where is Mr. Carmen? I was just trying to call you, Mr. Carmen. I need you on this. Tamika Brown, please. And then I don't know who has Ortiz. There's Mikhail Crawford's name on here. I'm going to need them in here too.
That's fine.
Okay. Your name, ma'am?
Tamika Brown.
Counsel?
Michael A. Carmen, P7384, on behalf of the defendant.
So she's going to plead to driving on a suspended. They are going to dismiss the no proof insurance and operating while texting, true?
Yes, sir.
And then we'll address the others. Is that what you want to do?
Yes.
If you plead guilty to driving on a suspended, the possible penalties are up to 500 fines, 93 days jail, costs are all those 2 points. Do you understand that?
Yes.
Did you sign, read, and understand it, and advice of rights form?
Yes.
Plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
To the charge driving on a suspended license, how do you plead?
Yes.
Were you operating a motor vehicle in the township of Brownstown on southbound Telegraph near Brutto, June 11 to 25 at 9:50 p.m.?
Yes.
Was your license suspended?
Yes.
Are you on probation or parole?
No.
It's actually revoked, right?
Yes.
Why were you driving?
That particular day, I was driving myself to the Woodhaven 24 hospital.
Anybody force you to plead guilty?
No.
Please accept it. I'm dismissing the no proof, dismissing the operating while texting. What do you have to say? Anything?
Your Honor, we just asked for an immediate sentencing of fines and costs and give Ms. Brown a little bit of time to pay.
I don't know if I want to give her time to pay. I'm going to be completely honest with you. She had a 2019 case. Back on April the 28th of 21, I took a guilty plea, ordered her to pay $35 a week after fines and costs were paid on the A file. And I let her pay $35 a week beginning June 4 of 21. We never saw anything of her. She never came in. She never talked to me. She never paid a nickel, as far as I could tell, until she posted these bonds. I don't know why people do that. I don't understand it. I'll never understand it. I can't understand it. I will never understand why somebody wouldn't come in and give me the courtesy of, Judge, I need more time. My engine blew up. My air conditioning went out. 6 years. 6 years you've been playing with us. So what else do you want to say, ma'am?
So on my behalf, my mom passed, so I wasn't mentally stable for anything, so she passed in 20. So I wasn't.
I'm sorry about your mother, that you could have come in at some point before you got arrested. 4 years later. Okay? Just think it's nonsense. How much does she owe on this one? She's light on the fines. I mean, she really is. She's got $460 on a bond on the 7-1B file. On the 7-1A file, what does she have with the bond, Lisa? Anything?
No, I only see one bond for 460.
Got a problem. Because honestly, between those two cases alone, you owe $890. And you had 6 years to take care of it. So what am I supposed to say? It's okay? I mean, really, truly, where do you work at? I'm sorry?
Fitty Post.
What do you do there?
I'm a mail operator,
How much do you make?
17 hours.
Then you didn't show up for a show cause in March of 22. Well, it's a good thing I'm a nice guy, because I could lock up people all day long, every single day. You know that? I'm serious. She acknowledges she owes the money on these two cases. Is that true? 606 and 284?
Yes, sir.
The 284 includes the clearance fee on that, right, Lisa? On the defective equipment? I'm sorry, the defective equipment, is that true?
No, there's no suspension on defective equipment.
Yeah, right. That's why, but they wrote up here 45. Maybe that was from.
Oh, it's because it's from 19. They used to suspend on that.
Right.
I can take it out.
So it's only $239 you owe on that. So here's what I'm gonna do. You're gonna pay $460. You're gonna sign the bond over on the suspend. You owe $239 on the other case. That is on the defective equipment. We're gonna set up a payment plan. On the suspend charge, which, you know, you're driving on a revoked, $100 fines, $300 costs, $75 victim's rights fee, $50 justice assessment, 5 1/4 or 93 days. So she owes 5 1/4 plus 239. That's 764 plus she owes 146, 864, 910 you owe. Now, you're gonna sign over the bond and then you're gonna tell me how much you can afford to pay. And I'm gonna give you time and then you're gonna give me the courtesy.
Yes.
Calling the court and going on Zoom with me or coming in here on or before a due date saying, Judge, I don't have the money. I need an extension, in which case I'm gonna be gracious about it. No matter if you have to do that 28 times, but when you ignore me, it does not make me happy. Do we understand one another?
Perfectly understand.
Good. Okay, so now I'm gonna let you be the judge and set up your own payment plan. How much can you pay per week or bi-weekly?
I'm gonna pay, well, I'm gonna pay, $50, well, just $100 a month.
You're asking for a lot. This is gonna take you 10 more months. Do you have children?
I do.
How old?
She's 16.
Are you married?
No.
Okay. All right. I'll do that with you. I'll do that for you. So let's have you pay first.
I can link them all together, Judge. If you just give me a start date.
Plan. She'll give you a printout. You pay $100 a month. We'll start that on August the 1st. If you need more time, you're gonna call the court, right?
Yes, I am.
You're gonna come in here, right?
Got my word.
Okay, good luck.
Thank you. Have a good day.
You too. John Alexander Ortiz, 25B1483777. Do I have the victim here on this case? Is the victim here anybody from Brownstown Forest View?
Not on.
Your name, sir?
Juan Ortiz. Michael A. Crime, B73824, on behalf of the defendant.
He pled guilty to telephone harassment. This was under section 771.1. It appears as though nobody is here from Brownstown Forest View. And I'll ask you to advise as to whether or not everything in the pre-sentence report is accurate.
Well, Your Honor, before we do that, my client has asked me to consider, he's considering wanting to withdraw his plea. I was not his attorney previously, so this is my first time with this file. Looks like there is some potential outstanding discovery that he would like to review, specifically a video. I'm aware that he put a plea in the record. I'm aware of what the court surely asked him. I know he signed his advice of rights and everything.
Said he'd been calling nonstop during the morning of February 18th. I mean, I don't care if he wants to try to withdraw his plea. I'm gonna need a motion.
No, I understand that, Your Honor. I'm just asking for an adjournment of the sentencing so we can submit that and see where it goes.
He had Mr. Gafe.
I think it was Mr. Crawford who signed the plea agreement. So I just need to take a little more time with this.
I'm gonna adjourn the sentence. Defendant will file a motion to withdraw plea. So we're gonna need Brownstown's input on this, Lisa. So when are we gonna do this?
August 21st at 8:30.
Is that the earliest I can do?
Well, that's the next time that Tony's here for Brownstown.
Okay. August 21st at 8:30. I'm not promising anything, but I would certainly keep an open mind. Okay? Anything else, Mr. Ortiz? All right, good luck. Go down the hall and get your notice. Thank you. Sean Mary Reed, 25G306478. Good morning.
You want this at the podium?
Please. How you doing?
I'm good. How are you? Good to see you.
You too. Appearance?
Abed Mahmoud, 354-908 on behalf of the city, to my left. Your Honor.
Ma'am, your name?
Sean Mary Reed, Your Honor.
Good morning. So this is a trespass. Does she stand mute where you form a reading?
Yes, Your Honor.
You've got an order for discovery. I'm signing that. The prosecutors approved it. And I'm gonna give her a personal bond, not to enter the premises though at 30515 Point Drive, $500 personal bond. You're not to enter 30515 Point Drive in Gibraltar. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed, no contact with prosecution witnesses. Except through your lawyer. Do you understand all that, ma'am?
Yes, Your Honor.
All right, so I'll give you a new court date. I'm signing your order. What do you have for me, Lisa?
July 31st at 10.
May I ask for, this is a neighborhood dispute over the property line. There's a civil case pending in Wayne County. I'm handling it. I spoke to the attorney there, and it could have an impact on this case. If a court, and I need to do some investigation on this case too, property-wise, not criminal type. Would the court give me almost 60 days for next date? Is that possible?
Oh, I can't do that.
Then just,
I'll tell you what, I'll give you 4 weeks, but
if you can.
I'm not going to.
Because it's not gonna be, I'm trying to solve it. Obviously, you know, imagine I'm trying to solve it. She has a ticket here and one with Judge Simpson for the same day, same thing. It's a dispute. I'm trying to solve it. I don't mind coming back to the court. I'm afraid I wouldn't have solved it, but if the court's gonna give me a date closer, could you give me the week of the 18th, Your Honor, because
the prosecutor's only here. What do you have, Lisa?
We're here July 31st and August 14th.
I can do August 14th.
I'm not in town. If the court may permit me the week after, is that possible?
They're only here every other. August 28th.
28th works, it's fine.
I know, but don't ask me for another adjournments, okay?
I hope I can have this. I understand. I appreciate that court's indulgence.
I'm just saying I can't, I don't write my guidelines. They tell me what to do up there in the Supreme Court. You know what I'm saying?
I know that.
And so that's what I have bosses too, and they tell me what to do. I'll give you August 28th at 8:30, and, but I'm gonna put down no more adjournments. Maybe they can resolve the whole thing there, and I hope they can, and you go down the hall and get your notice. Anything else?
No, thank you.
Have a good day. Good luck, ma'am. Thank you, Michael Lanier Green. Thanks. We're gonna give you a printed notice, okay? Michael Lanier Green, 25T645745A and B. And I'll need some more files up here. I see Mr. Gates here. Where's Mr. Green? How you doing, Mr. Green?
Good, so.
Not too bad. Your name? You're charged with driver license expired.
Correct.
You have the right to a lawyer. If you want one, I'll give you one. Or I'll arraign you and let you talk to the prosecutor. It's up to you.
When will I be able to talk to the prosecutor?
Today,
Today?
in 5 minutes.
Okay, and I talked to the prosecutor, will I be able to make a decision as far as?
If he doesn't give you what you want, you can come back in here and say, Judge, I want a lawyer now. But, so I'll arraign you? Is that what you want? And send you to the prosecutor?
I'll talk to the prosecutor.
I gotta arraign you first. Okay, so I'm gonna explain the charge. It's not that complicated. They just think you were operating a motor vehicle on June 24 of 25 in the city of Trenton with an expired license. That is a misdemeanor. It is punishable by up to $100 fines, 90 days jail. Costs are all those 2 points. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? You still wish to waive your right to a lawyer? If you do, I'm gonna enter a not guilty plea and send you to the prosecutor right now. If you don't, I'm gonna give you a lawyer. It's up to you.
I don't want to waive my rights, I can tell you that, so.
Well, you do what you want. If you want a lawyer, I'll give you one. If you want to tell me, Judge, I waived my right to a lawyer, I'm gonna send you to the prosecutor. If you go to the prosecutor, he doesn't give you what you want, you come back in here and tell me, Judge, I want a lawyer. It's up to you. You're not permanently waiving it if you don't want to do, if that's what you're concerned about.
I just said, I want.
Okay, we're gonna give you a lawyer. I'm gonna enter a not guilty plea. I'm gonna give you $100 personal bond. You cannot, and then by the way, I'm entering a plea of denial on the license plate charge. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand all that? Any questions?
No.
Okay, so you go talk to the lawyer will talk to the prosecutor, you'll both come in together. Good luck. Scott Parker, 25T645621, A and B.
Good morning, Judge. Mass and Judge Prendergast, Mr. Parker.
Your name, sir?
Scott Parker.
Does he stand immediately formal reading?
Yes, sir.
Not guilty, please, entered. I'll give him $100 personal bond. I don't know where he was on June 26th. Why weren't you here?
I missed the, notice. It went to my sister's mail. He's in between addresses, Judge, and he went to a different address.
$100 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. They want an adjournment. We can give them July 31 on this if Trenton's here.
July 31st at 10 o'clock.
10 o'clock. Okay, sir?
Thank you.
You go down the hall, get your notice. You are going to have to fill out a petition for a court-appointed lawyer, though. So make sure you sit down there. We'll give you a court-appointed petition, and I'll decide whether or not I'm going to appoint you a lawyer. Where do you work at, sir?
Texas Roadhouse,
How much you make there?
18.
You can fill out a petition if you want a court-appointed, okay?
He doesn't need one.
Good enough. I'll just note that you're waiving it. Good luck.
No, you don't pay.
Brandon Scott Chandler, 25T645681.
Good morning, Judge. Mass and Judge Prendergast, Mr. Chandler.
Okay, the problem is, your name?
Brandon Chandler.
He's gonna try to get his license reinstated, and I don't have a problem with that. I'm entering an act, does he stand me away
We'll
from
stand
me?
in wait.
I'm gonna give him enter a not guilty plea. I'm gonna give you a $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'll give him 4 weeks, but don't be asking me for a lot more adjournments after that, so you better go talk to a lawyer today. Do we have something on the 14th?
August 14th at 8:30.
At 8:30, okay? At 8:30. Go down the hall, get your notice. Any questions?
Thank you, Your Honor.
And if you want a lawyer, sir, come on back up here. If you want a lawyer on this case, you can fill out a petition for one, okay? If you can't afford one. Do you understand that?
That's the only, I can probably, I think we got some insurance.
Okay, good enough. We'll see you back here. Good luck. Jason Welsh. Jason Richard Welsh, 25T645761. Could I have Gabriel Hash seated at the table here? My right, your left, as well as Amy Brown, seated at the table there. Your name, sir?
Jason Welsh.
Counsel?
Mass and Judge Prendergast, Mr. Welsh, we stand in wait.
Not guilty, please entered. He wants an adjournment so he can clear the suspension. You can $500 personal bond. You cannot leave the state without consent. You can't violate a law. You must appear in court as directed. July 31, Lisa?
You want to go 2 weeks?
Yeah,
Okay, July 31st at 10:15.
10:15, okay? If you want a lawyer going forward, you're gonna have to fill out a petition for a court-appointed lawyer, okay?
Yes, sir.
Best of luck. Gabriel Grace Hash, 25G306488.
Good morning, Judge. Mass and Judge Prendergast, Mr. Hash.
Your name, ma'am?
Gabrielle Grace Hash.
We'll stand in wait, Judge.
Not guilty, please entered. Colin, would you get Detective Robinson? Detective, can you come in here, please, and tell me your name?
Sergeant Gary Robinson, police.
So I've been fighting this war for 30 years, but I need somebody to put on the tickets who the victim is. Just a short description. I feel like a less than stellar judge when I just say no contact with the victim and I don't know who the victim is.
Okay.
That's all it says on the ticket. It'd be nice if they said, did punch in the face or did push or did slap the victim, Jane Doe, or whoever it is. Same thing with retail fraud. They can at least indicate the value of the ticket, of the item stolen. gives me, and where it was, and I can get an idea, okay?
Gotcha.
Ma'am, I'm gonna give you $1,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. You're not to have any contact with the victim. You're not to have any contact with prosecution witnesses except through your lawyer. And you are required to go to the Gibraltar Police Department to get fingerprinted and photographed by 1:00 p.m. today, okay? By 1:00 p.m. today. We're gonna give you an order, and you have to take that order over to Gibraltar and the police department, and they will print you and photograph you, okay? So you're gonna go down the hall and get your new date, and that will be on,
July 31st at 10.
okay, July 31st at 10 a.m. All right, ma'am? Any questions? We'll give you a bond sheet. We'll give you your notice. We're gonna give your lawyer the order granting discovery, and we're gonna give you your order for prints that you have to take over to Brownstown. I'm over to Gibraltar, okay? Good luck. Thank you. Thanks a lot. Brown, Amy Diane Brown, 25T645864 A and B. Can I have seated up at the table here? Andrew Siak. Your name, ma'am?
Amy Diane.
Good morning, Judge. President, on behalf of Ms. Brown.
She stand mute, wait for more rating?
Yes.
We're gonna adjourn this $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm gonna give you a new court date. Personal bond, $500. I'm entering a plea of denial on the civil infraction. Let's do July 31 on this
10:30.
at 10:30. Okay, ma'am? So you go down the hall, get your notice, and then come back on that date. Any questions?
No, sir.
Good luck. Where is the file that the interpreter has, Ms. Villarreal? Whose is that? Where is that? I want to get her out of here.
It's, Tony's doing all the Brownstown.
People against,
I'll go get it.
that's all right. I mean, Andrew Steven Syak, 25T642904.
Say your name. Andrew Stevens, sorry. Good morning, Judge. Navigate on behalf of Mr. Syak.
What?
Taking time set for sentencing this matter?
He pled to attempted drug paraphernalia.
Correct.
I tried to get him into sobriety court, right, sir?
I don't believe so. I think you were considering it.
You didn't want to do it, though.
I wasn't asked if I wanted to. I was given the paperwork to look over. That's really it.
But you told them no, right? You don't want to do it?
Ideally, no.
Well, okay, I don't know what that means. Ideally, no. I don't know what you mean by that. You didn't want to do sobriety court, right?
Seems like a very long process, yeah.
All right, just give me a straight answer here. Yes or no? You didn't want to do it, right?
No, I did not want to commit to a 2-year program.
Okay, so I got a problem here. You got a problem, not me. You got a case going on over there, possession of a controlled substance in front of Judge Fleischer. You violated your probation. I ordered you to test weekly. Every test has been positive for cocaine. You have another drug charge. You don't want to do sobriety court. You're violating her probation left and right.
I'm sorry, Your Honor, what's the other drug charge? I just had the one with Vesta.
Well, this is still, I mean, it's drug paraphernalia, but it's still related to drugs. If you want me to say it's just drug paraphernalia, that's fine. But did you not have, there was cocaine in the car, right?
Oh, yes, Your Honor.
Right? And you told them it was baking soda, right?
No.
You didn't tell them it was baking soda?
No, when I was caught with cocaine in the car, it was cocaine.
See, I advised that the bag in the console was baking powder. You didn't,
I didn't tell them that. They must have found that.
Okay.
I wasn't caught with drugs on me for this case.
at the station, the orange vangy was field tested, which tested negative for narcotics. The SEAC advised the bag on the console was baking powder and there were no drugs in the vehicle. Powder on the spoon was tested, which tested positive for cocaine.
I wasn't aware of this.
You're just going to use cocaine and drugs till you're 80. You don't want to.
I've got a drop. Okay.
What's that?
Oh, yeah. I was just tell him to let you finish.
Well, you test. I mean, look, it's your life. You're 39. You know, if you're gonna go on using drugs the rest of your life, that's up to you. I can't stop you. But I can do what I'm gonna do right now. And that is you're showing no remorse. You're showing no sign of letting up. You said you're still gonna drink alcohol to them. I see no need, no reason to put you on probation again. That means there's only one other option, and it's the one you're not gonna like.
Can I speak, Your Honor?
You absolutely could speak. Did you come in here on this?
Yeah, I could just hear him saying that I didn't go over sobriety court and I did.
Hang on. Don't interrupt. Tell me your name.
I wanted to see him.
Hey, don't interrupt her.
I'm sorry.
You talked to him about sobriety court.
I did, and it was a very similar conversation that the two of you are having that.
He doesn't want to stop. He's gonna go use and he thinks this is okay, and I guess it is until you die, because I have it happen all the time. By the way, Mr. Siak, I got people coming in, close file, defendant deceased, close file, defendant deceased. If that's what you want, I can't stop you.
Your Honor, I've dropped all other substances, and I am putting an effort into cleaning it up. My last 3 tests came back with only the cocaine substance. I stopped the drinking. I am putting effort in, you know, just I
This defendant is tested positive for cocaine on all 4 drug alcohol tested. What is that supposed to mean? Do you want me to put a gold star in your head that you're just using cocaine now instead of alcohol or something else?
No, Your Honor, I'm just saying I was working my way off a few substances and making changes, and you know, it's been a process. But I am putting effort in.
I just want to read you the record.
Yes, sir.
Defendant also created one of his tests by bringing a urine bag to testing. Okay. Also tested positive for alcohol, benzos, amphetamines, and methamphetamines. So I don't know what to tell you.
I'm saying my tests are a lot cleaner than that now. So if I'm allowed a little more time, I can show that I can make changes.
Did you review the report?
We did.
Any material additions, corrections, or deletions?
No.
Anything you'd like to say in his behalf?
Yeah, just that, other than what Mr. Syed said, he's told me that he's trying to make an effort, he's trying to clean himself up. Obviously, he did lose his job as a result of the house arrest that he was under. But he was gainfully employed. He does have a 19-year-old child that he actually must be a good role model for a judge. We're asking the court to adopt the recommendation for probation. Obviously, I understand the court's hesitation, but we would ask the court to allow Mr. Syed a chance to prove what he said here today, Judge, is true, and that he is in the process of actually trying to make an effort to clean himself up.
I admire you, Mr. Gave. You're doing everything you can. Sometimes defense lawyers they're up against it. You know what I'm saying? Gave is a good lawyer. Tries hard. I apologize. I interrupted.
I'm all set.
Thank you. And Mr. Siak?
No, Your Honor, just I'm making an honest effort. I've done a substance abuse evaluation. I'm doing my meetings. Like I said, all those other substances are.
Where's your proof? Let's see your AA proof.
I have the meetings listed on my phone because I've been on house arrest. So I've been doing it online.
Who put you on house arrest?
The court here.
I didn't.
It was for Hessen.
Judge Hessen?
Yeah.
Additionally, I believe Mr. Syed is also on probation. Another matter, we ask any probation allow run concurrent with that as far as testing and other conditions.
And yeah, I've been doing Thursday, Saturday, and Sunday meetings. Thursday, I've been doing the Lily House.
What good does that do if you're continuing to use? And then you look me in the eye and you lie to me. You tell me you just got it down to cocaine, and they tell me you've got all these other substances, and you got alcohol, and you don't want to do drug court. And you tell me that you did. I didn't quite tell you to do that. Probation officer hears this. Mr. Siak.
Your Honor, no, I'm saying like my earlier tests had all those substances. My last few have been down to just the one.
So the probation officer's lying.
Yeah, if they're saying that's not the case, then yes. I mean, I can.
Call
give my
Jessica in
results.
here. Call Jessica in here.
It was Emily, Judge.
Jessica was the one that was overseeing this one, but Emily talked to him about drug court.
Yeah, I tested yesterday.
Slow down, just slow down. Let's call Jessica in here.
She's already.
I definitely have a violation.
Mr. Siak. And then you bring a urine bag in to test.
Oh, it's so expensive, Your Honor.
What's so expensive?
The testing positive. They charge extra money for every substance.
What are you talking about? What are you talking about?
I believe he's talking about when he just put on behalf of probation. When he tests positive, he's paying for the lab confirmation, so he's paying an additional 25 each time he tests positive for a substance to confirm it.
I know, what's that have to do with him trying to cheat on his tests and bring in a urine bag? Am I missing something? Oh, so if you bring in a urine bag and you cheat, you fraud us, then you don't have to pay for the confirmation test, right? Is that what you're saying?
Answer his questions, absolutely.
Yes, Your Honor.
Okay, I just wanted to clarify.
Judge,
He keeps saying he cleaned up on all these things. He said,
So he's tested positive. His first test was May 16th. He's been positive on every test since then.
not just for cocaine, but for amphetamines, meth,
Yeah, so
alcohol.
his first two tests, he tested positive for alcohol the first two times he's done, and since then, his most recent two tests are negative for alcohol, but he's still positive for cocaine.
How about methamphetamines?
His most recent test, he was negative for methamphetamines on his most recent last two. So that was July 16th and July 8th, he was negative for methamphetamine.
Okay. Well,
Still
that's
positive
good.
for the cocaine.
So you're just down to cocaine.
Yes, Your Honor. I'm working on it.
Judge, also too, the house arrest is related to a pending domestic violence case he has with Judge Hessen.
What's that?
He has a domestic violence case that's pending, that's due to the house arrest. That's a Judge Hessen case that's pending.
That isn't the one from 2017. That's a recent one?
It's a recent one, it's a new one. And then he's on probation with her as well on another charge. She does have a violation with her today.
Anything else? Anything else?
No, Your Honor.
I can't help the people that don't want to be helped. 250 in fines, 200 costs, $75 victims' rights fee, $50 justice assessment. That's $575. Attorney fees are 40, 615, 21 days, credit 1, serve 20 now, and you're going to serve 25 more if you don't pay your fines and costs. I'll let you pay those at the rate of $50 per week. I will start this beginning on September the 5th, give you a little bit of time. If you don't have the money, you call the court, sir. We'll go on Zoom on it before the due date, or you can walk in here 8:30. I'll be glad to give you an extension, okay?
Judge, just for clarification.
He's in custody.
I can say about how much 700?
I haven't checked that on the site.
Roughly about 700 last time?
Yeah, fines were already issued, and I paid up what was due currently.
On this case?
That's why I was finding a little.
How could you have paid on this case?
Right.
This was a personal bond. I don't find people before I sentence them.
Sure you paid it on this day?
It's gotta be
Paid his
another.
other case off
Yeah.
in full, that probation case.
So that's what I'm doing on that.
That's a little bit, it's not. Go right to the door here. Thank you, Judge.
Mr. Siak, please heed my warning. You need to get yourself some help
Yes, Your Honor.
before you're dead.
Yes.
Really?
Is it possible to line up turning myself in? I'm trying to report stuff, but there's some things I would like to
No, sorry. Elias David Cavallero, 25T644066, 23T638, 649. Hang on one second. And then I have 23T640394R. your appearance.
Good morning, Judge. May I name Mr. Caballero? State your name.
I is David Caballero.
So I'm gonna go ahead and dismiss since victim does not wish to proceed on 25T644066. So let's get rid of that one. That's dismissal. Why, Lisa, this is not.
They both are in warrant status for payment, non-payment.
Okay, so this is disorderly and he owes how much on this?
Let me check.
Can you pull him up?
He owes $480 on disturbing the peace and $100 on loitering.
Actually, the one that I have in front of me, the 94R case is $100. It looks like he still owes. I don't have a loitering case in front of me anyway.
That was loitering, that one, 94R.
Oh, I see. This is Judge Heston's. This is Judge Heston's, actually, the 94R that was pled to loitering. Can you pay all this?
Judge, Mr. Caballero has a number of mental health issues. He hasn't worked in quite a while. He's currently, today, apparently, a bed just became available to him. Is that correct?
Correct.
Can you tell the court where?
Don Barnes. I have to, first I'm going to detox at a hospital, and then I'm immediately going to Don Barnes afterwards.
Okay.
We asked the court to allow Mr. Caballero to go through the program, and then the court would set him up on a payment plan.
Yeah. Lisa, so let's just put it out there, 45 days. How's that?
It's a 90-day program, Your Honor.
Okay. August, September, October. What's the first Friday in November?
The 7th.
You pay $50 per week beginning November the 14th, okay? On this disorderly file, all right? And then I'm just gonna give you pay, he's not on probation. You pay the $100 on Judge Heston's case by December 15th, okay? If you need more time, you come talk to me, all right? I will give you an extension. Just show me the courtesy. I gave you an extension last time and I told you that. You didn't come talk to me. You got to come talk to me, okay?
I just recently, I haven't had a phone. I just got a phone again, so
Well, you can walk in. You're all set. Good luck. Thank you. Sonia Adalia Gonzalez Corona. 25B148788A. All right, you're still under oath, Ms. Villarreal. Your name?
Your Honor, Evelyn Villarreal.
Counsel?
Michael A. Carmen, 3738224, but after defendant.
She stands mute, waives formal reading, right? She has a valid license. They move to dismiss now, right?
Yeah, sure.
Case dismissed, young lady. I wish you well. Good luck. Hola, ¿qué tal? Okay, good luck.
Thank you,
Sorry.
Your Honor.
Have a good day. Thanks a lot for your help as always. Jim Construction Services, LLC, 25D645896, A, B, and C. Who are you, sir? Come on up to the podium. Tell me your name. What's your name?
Gerard Garcia.
Spell your first name.
Gerardo.
Gerard. Gerardo. Gerardo Garcia.
Yes, sir.
What is your position there?
I'm a lawyer.
You need to get a lawyer. They need to get a lawyer. Okay? I'm gonna adjourn this, but they need a lawyer. They need to hire a lawyer. Do you understand that? So I'll adjourn it. They have to show up or else we're gonna show cause the president of the corporation, okay? So I'll give you a new date, July 31, Lisa?
Yes, 10:45.
10:45. You can go down the hall, get the notice. I'm not going to arraign you. They have 3 charges: spill load, defective equipment on a commercial vehicle, and improper display of a plate on a commercial vehicle. They need a lawyer. Okay?
Okay.
Best of luck.
Thank you.
Thank you. Make sure they come back with one, okay? Tell the president.
Yes, sir.
Thank you. People against. Ali Kamal Bazi, 25G, 306, 425 A, B, and C, and I'm gonna need Ms. What happened here? Your name?
Yes, hey, good morning, Judge.
Oh, you had to file a motion to withdraw, didn't I?
Yeah, so I had it written and I had to file like 3 of those motions. I must not have sent it, but I just sent it this morning.
Judge, I thought there was one in the file. I did receive it.
Okay, good.
Did?
I can bring another copy down though if you need it.
Hang on, let me see. It must be in here then. I don't have it in here. I don't have one in here. I'm gonna need somebody to bring that down.
Okay, I'll run it down.
I'm gonna need Ms. Zelnick on this other case. Can you tell Jessica? Can you go and get Ms. Zelnick?
Who is Ms. Ellman?
She should be in conference room 3. She should be in my conference room.
I will get her in here.
Give me 1 second. I need to look at that, counsel, okay? I'm not gonna give you a hard time, but I don't see one in the file here, so. He's not here anyway. Let me call this other case, Braden Honey versus City of Gibraltar PD, 2502495. Come on up here, sir. Good morning, Ms. Zelnick. How are you? Your name?
Good morning, it is on that the City of Gibraltar.
Good morning, Your Honor.
Your name?
Braden Hunt.
How you doing?
Good, how are you, sir?
So he's filed a complaint and a claim and delivery complaint. He wants what? You're going to describe those vehicles for me momentarily. So do you have any objection?
No, Your Honor.
Lisa?
Yeah.
You have Jennifer log on.
She's out there.
Jennifer, are you out there?
Yes, Judge.
Give me 1 second. All right. So I've got the order of possession pending judgment. There's another SCAO approved order.
Do you want the judgment for claim and delivery?
Correct.
Okay.
So send that one down and I'll
Okay.
read this case momentarily, okay? I have to call you in again.
No problem.
If they send that to you, maybe you two can just sign it and agree to it and send it in and I'll recall it. I won't have to bother you again, okay?
Excellent, yes.
Thank you.
Thank you. It's always.
Are you doing all right?
Yes, sir.
Are you? So
Absolutely.
you got yourself some treatment and you're doing well?
Yes, sir. I was just going through a rough patch in my life, you know, and as a young man, I served in the United States Marine Corps.
No way.
And my best friend I served with, from the footprints, he killed himself, and then
Oh my God.
it was a chain event of just awful things.
I'm so sorry.
But I've worked through that and I'm doing substantially better, and I have a job interview with DTE next week.
How old are you?
22, sir.
Did you go, how many years were you in the military?
2.5, sir.
My father there on the wall was a major. He was really, he loved the Marine Corps.
phenomenal organization.
And I thank you for your service. Let me get this order and I'm gonna get you out of here as soon as I can, okay? And I mean that sincerely. Thank you very much for your service.
Absolutely. Thank you for your time, sir.
All right, back on the record on Ali Bazi. This is 25G3064, 25A, B, and C. All right, counsel, I have your motion now. It just wasn't in the file. My apologies. Your appearance.
Or Abdullah Mugni, P number 85374, here on behalf of Ali Kamal Bazi, who has not appeared today.
Lisa, we also issued a show cause for Mr. Bazi, right?
No, today was an arraignment pretrial date.
Somehow I wrote issue show cause on here.
Let me check real quick.
I'm going to allow you to withdraw, counsel. I don't have an order, though. If you could submit the order. I've looked at it, and I'm going to go ahead and issue a, was this set for a arraignment and pretrial also, Lisa?
It was. It looks like previously the attorney appeared and the defendant did not. So then we adjourned it.
We just didn't issue a show cause.
Right.
I'm going to allow you to withdraw. You prepare an order. This is a willful intent by defendant to delay adjudication. I'm issuing a warrant. 3,010% will be the amount of the warrant. Counsel, submit your order granting, allowing you to withdraw. Okay, will you do that for me today, please?
Most definitely. Thank you, Your Honor.
Have a great day. Thank you very much. And by the way, please, on B and C, since the defendant was to be here, I'm entering default judgments on both of these, okay? Thank you. Have a good day, counsel.
Okay, Judge.
You too, Judge. Thanks.
All right. Okay, I don't have anything else ready right now, so I'm gonna get off. What's your name, sir?
George Grass, the
Okay, did you talk to a lawyer today? Which one?
Mr. Gates.
Okay. All right, we'll try to get you out of here. Can you talk to Mr. Gates about him? That's a sentence, compulsory attendance.
Hey, Tabitha.
Yes, ma'am.
If you talk to Mason, can you tell him that Pittman is on Zoom? She's in jail.
Yes, perfect, thank you.
Sergeant Benares, can you hear me?
Yes, I can.
Just waiting on the jail to log in.
Okay.
Do you want me to call you or do you want to hang out?
I'll just hang out.
Okay, thanks.
All right. Thank you.
Perfect, thank you. Bye. I let Mason know.
Thank you.
You're welcome.
Go and have a seat now.
These are, okay. Court does call the case of the people versus Jonathan Hughes.
Sherilyn Foster Tucker on behalf of Jonathan Hughes.
Client down in our jail has refused to be seen. So I will adjourn this out.
Okay.
August 7th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Court calls the case of people versus Elizabeth Hill.
And good afternoon, Laura Yagi, Assistant Public Defender with and on behalf of Ms. Hill. Your Honor, I do have a green sheet. I apologize. I am seeking an adjournment for further discussions regarding the case.
And no objection, I did want to just,
Probable cause conference, August 7th, 2025, 9 a.m. Yes, Esteban.
simply wanted to request, there is no testing order whatsoever on this file. I provided the court, you may have the hard copy of, Ms. Hill's. I think it started with Choboling, she may now be on scram or vice versa in her circuit court case. I just wanted to ask, Choboling, she may now be on scram or vice versa in her circuit court case. I just wanted to ask that we have an order here to accompany that so that we get those results, because currently they're only being sent to,
Oh, you guys don't get them. I get them because of the game, but I got you. You're on a
Scram
now. Right. When did you go on a scram?
They put it on me before I got out of jail, July 8th or 9th.
All right. What I will do is I'll continue the defendant's bond. And we'll order a scram tether on this case. We don't have to put another one on.
Thank God, we're not a space.
What do you say?
We're not a space.
We got two left, so we can put one on each leg. That's been done there.
Your Honor, I'm so sorry. I'm just asking for civil standby. I think it was an oversight at arraignment, but we just need a civil standby for her to get her belongings.
To do what?
For her to get her belongings from her residence. She's been evicted, but it is the location that she's not allowed to go back to. But she was told that she could get her belongings with a civil standby. And for some reason,
I don't need to order a civil standby. You called me.
They wouldn't come out when I tried to do that. I said I had to be ordered by a judge. I'm not allowed on the property.
So I don't know if
Sheriff's Department told you that?
Yes.
If I scream loud enough, is that an order? Really? I've never. Ms. Yagi, craft an order.
Okay.
That's not how that works.
I was going to say, I'm happy to just send them JIS if the court just indicates like, okay for
Do an
civil.
order. They want an order?
Understood.
Do an order.
Got it.
People out of room, I'll put a big signature on it.
Thank you, Your Honor.
All right, thank you. Court does call the case People versus D'Angelo Simmons. Also.
People, Your Honor.
Okay.
On behalf of D'Angelo Simmons. So the client is
Where's your client?
admitted to restoration treatment on the 14th.
So where is he?
Not here.
Why?
Because he's getting treatment.
We got plenty of people getting treatment. Why isn't your client here?
We would like to.
Okay, I'm messing. Look, the reason he's not here, he's in the forensic center. There was no way.
So we would like to adjourn this matter.
You had no clue. Kind of did, but never mind. All right. Probable cause conference. We'll adjourn this out to the 8th or the 7th. I'm sorry, August 7th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Oh. Okay. All right. Let me. Hold on one moment, folks. Oh, there you go.
I'm tucking in my shirt for you.
No, you don't. Ready, do you solemnly swear for the information contained in the search warrant affidavit is true to the best knowledge information? Court does call the case of the People versus Dutton Howard.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Howard, who is now approaching the podium.
State your name.
Don Howard. At this time, Your Honor, we'll be requesting an adjournment to have video discovery be provided.
All right.
And here's a green sheet for you, Your Honor.
You're looking for video discovery.
That is correct, Your Honor.
During this to August 7th, 2025, 9 a.m. Bond continued.
Okay.
Thank you.
Your Honor.
Court does call the case People versus Sherry Hughes.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Hughes, on behalf of Mr. Gaddy. Not with Ms. Hughes, Your Honor. My understanding is that our office has attempted to reach Ms. Hughes several times and we've not been able to get in contact with her. I'd ask for an adjournment for the record.
Bench warrant will issue bond 10,000 cash surety. That warrant will issue immediately.
Thank you.
Thank you. Court note. Yes, go ahead. You may.
Good morning, Ms. Liliana. You're in front of the Honorable Judge Cedric Simpson out of the 14th District Court, Washington County, State of Michigan. We need your assistance with one matter this afternoon. Our number is 1423.
Yes, certainly. I'm ready with your instructions.
Please raise your right hand to be sworn. Do you solemnly swear or affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, and translate from English into Spanish and from Spanish into English, in the manner now before the court? Tell us that.
Yes, I do.
All right. Court does call the case of the people of state of Michigan versus Jorge Lopez.
Jennifer Douglas for the people.
Sorry,
Jennifer Douglas for the people.
No le seré su intérprete de español el día de hoy. Este sería el caso del estado de Michigan contra Jorge López. De parte de las personas del estado sería Jennifer Douglas.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Lopez.
Y a favor de parte del señor López, abogado de la Oficina del Defensor Público, Nicolás Bakovich.
Defendant is requesting an adjournment in these matters. I will adjourn the probable cause hearing to August 14th, 2025, 9 a.m.
Your Honor. Sorry.
Pero el acusado estaría solicitando que se aplace esta audiencia para tener la audiencia de causa probable. Se estaría aplazando, moviendo para el 14 de agosto del 2025 a las 9 a.m.
Yes.
I do have a meeting set up with Mr. Lopez, and
I understand. I read the form, which shouldn't say what it says, and we'll talk about that.
Understood. Thank you, Your Honor.
Sí, entiendo
get
de que bueno, mencionaba su abogado de que tenía una reunión con usted, con el señor López, y después menciona de que sí, entiendo, leí lo que dice la forma que no debe decir eso y vamos a estar abordando eso.
Bond will continue. Thank you.
Se va a continuar, gracias.
Alrighty, thank you, Madam Interpreter. Can counsel on the last case approach, please? Thank you, Madam Interpreter.
Sí, oficial services, have a good day. Bye.
Did not hear you call.
Okay. Court calls the case of the people versus Shafi.
APA Rachel McDuffie for the people.
Good afternoon, Tina Sachs on behalf of Mr. Shafi.
Mr. Shafi here. Yeah, very.
I'm here to see Germans because he's. Okay.
Sir, please state your name.
Rashad Shafi.
All right. All right, what are we doing on this case?
Your Honor, my understanding is that Mr. Shafi is currently set for preliminary exam, which are being adjourned because he has been in treatment, got out, is in treatment again. So we, I believe counsel's request is to adjourn this case. I want us to quickly address bond on this one as well, just for the same administrative purpose I did on the other case I had.
All right. How much time do you miss action?
Your Honor, I'm asking for 3 weeks. Mr. Shafi's supposed to still be in the program for a total of 28 days. He just went in on the 14th, so I was hoping to.
Gotcha. All right, I'll adjourn this then to August 7th, 2025, 9 a.m. All right.
Thank you.
Mr. Bond.
And Your Honor, regarding bond, there is a testing order on this case, but I just provided the court, I think via email, it might be in the file. Ms. Shafi's technically in violation on this case, but Community Corrections has 2 sets of reports that don't overlap. So I just provided the court with his other report from those previous 2 cases that were set for exam so that you had a copy. It appears that he briefly relapsed and then went back into treatment. So
I was in a motorcycle accident, so I missed my time.
Mr. Shafi.
Yeah.
I'm sorry.
He was, I remember from the last time, there was an accident, he was in the hospital and he missed his testing. And then he's good with me.
I just provided a copy because they
Thank
didn't send it to me.
All right. Okay, thank you, Bond.
Thank you,
Your Honor.
Court does call the case People versus Emily Bates.
And with that, on behalf of Ms. Bates, who's appearing on Zoom. Ms. Bates, can you please state your name for the record?
Emily Bates.
Thank you.
Your Honor, we are going to be asking for an adjournment. We need to get proof from Ms. Bates regarding treatment in pursuit of a plea offer. So we're gonna be asking.
August 7th, 2025, 9 a.m.
Thank you.
Bond continued. Thank you, Ms. Bates.
Thank you.
Court calls case People versus Desmond Jones.
Hey, we're doing good for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Jones. Your Honor, I will need to fill out a green sheet. I did not have contact with Mr. Jones. So I will.
Because if you had contact, you
I would have told
about
him
appropriately
that he
dressed.
had to wear pants. Yes, Judge.
Yes.
Yeah. So I will
We
get a
won't
green
see
sheet.
that the next time if I grant you adjournment.
No, absolutely not. Yes, he will have pants on. If I could have an adjournment so that I can get updated contact information with Jones, and I'll get a green sheet to the court.
July 31st, 2025, 9 a.m.
Thank you, Judge.
I'm continuing.
Thank you.
That's what it sounds like. She does not don't listen to you. She has no idea. Court calls the case People versus Dominic Kelly Payne.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Kelly Payne, who I do not see here in the courtroom. Judge, I did talk to Mr. Kelly Payne yesterday. He did have court in the 22nd Circuit Court this morning. My understanding in corresponding with Ms. Nevesky that he was there, and Judge Kunke and their team came up with a plan of action for Mr. Kelly Payne. I expected him to be here in person. He discussed.
Did he like the plan of action they came up with?
Yes, I believe so. It allowed him to remain out of custody and a treatment plan so that he can stay compliant with drug treatment court. I don't know why he hasn't made it here yet. But considering that information, I'd ask the court for an adjournment.
That admission probable cause conference will be adjourned July 31st, 2025, 9 a.m.
Thank you, Judge.
That was so nice of me. Miss Apple has a nice way of asking. Don't buy it all the time, but. Court calls the case People versus Coran Lee Master.
Hey, Pierre, we're doing good for the people.
Probably just LeMaster.
My name is Alex Parks. I'm requesting permission to practice pursuant to Michigan Court Rule 8.120 under APD Hannah Apple.
She.
Fantastic. Yeah.
Okay. She wants to keep handling cases.
All right, your name, sir?
Corrado Master. All right. Permission to practice is granted.
Thank you, Your Honor. We're requesting adjournment in this matter to give us more time to discuss with our client.
Discovery. All right. Probable cause conference will be adjourned August 7th, 2025, 9
Thank you, Your
a.m.
Honor.
Or as your invite indicates, bond will continue. Thank you, Mr. Thank you, sir.
Thank you.
Court calls the case of the People versus Derek Martin.
That is for the people. Patrick Cannon on behalf of Mr. Martin. Mr. Martin, when you are at the lectern, please state your name.
Derek Martin.
Thank you.
And we are simply requesting an adjournment, Your Honor. There's some outstanding discovery and I don't have one.
Get the form to us. I'll sign off on it July 31st, 2025. Bond.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Harold Martin.
Echelon of the people.
Assistant Public Defender Nicholas Buckovich on behalf of Mr. Martin.
Harold Martin.
Yeah, Your Honor, I have been trying to make contact with my client. I was unable to do so. I'll be requesting an adjournment.
Your Honor, can I ask a question as to previous bench issues?
As to what?
I think there's been previous warrants in this case, is that correct?
I do not know right off the top of my head, but one, yes, there was one April 24th.
Are you able to tell if he posted the bond?
I don't see it as posted, but it was a recall.
And I will also note for the record, there was another bench warrant that was issued on April 4th, 2024, that I think got recalled.
I don't know.
Okay.
We can assume for the sake of argument it was, so. Bench warrant in this case will issue. Bond will be set at 10,000 cash surety. That warrant will issue immediately. Court calls case People versus Robert Martin.
And Assistant Public Defender Nicholas Buckovich on behalf of Mr. Martin, who is now approaching the podium.
Your name, sir?
Robert Martin.
Thank you.
Today, Your Honor, will be waiving a preliminary exam, so Mr. Martin can pursue offer under 7411 in the circuit court.
Sir, is that correct? You're waiving your right to a preliminary examination?
That is correct, Your Honor.
You understand that's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count.
And I do have a waiver filled out for you, Your Honor.
It's your turn.
Yes, Your Honor. As it relates to the charges, we will waive a formal reading and my client will be standing mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pre-trial in this matter will be set
September 4th at 1:30 with Judge Slay.
September 4th, 2025, 1:30, Judge Slay. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you.
Your Honor.
Court calls the case of the People versus Makisha Melchor.
Okay, Rachel McDuffie for the people.
And Laura Yagi, Assistant Public Defender, hopefully with and on behalf of Ms. Melchor. I know she was having some issues logging in. Ms. Melchor, can you unmute yourself and say your name for the court?
Oh, there she is. All right, so you, there you go. You have it. State your name.
Makisha Melcher.
Okay.
Honor, we are respectfully asking that this case be set for exam.
All discoveries complete.
To my knowledge.
And I just want to confirm, apparently there was some discussion of a misdemeanor offer if or submitted that Ms. Melcher completed treatment. I'm confirming that potentially for offer things, maybe that will be approved. We're coming at him, so, sorry.
That, I guess I'm confused. There was no offer, and so we're setting it for exam. I'm not,
That's the correspondence that we had, but that's okay. Well, Your Honor, can we pass it for about 30 seconds, please?
Why? Is there an offer or not?
Council emailed me, requesting an update on a potential offer to be discussed. I responded asking if she had the documentation that was requested for that offer, and here we are. So,
Your Honor, we're setting it for exam. There's no offer.
Preliminary examination in this matter will be set for July 29th, 2025.
Thank you.
9 a.m. before Judge Washington. Bond will continue.
Thank you.
Thank you.
Thank you, ma'am. Court does call the case, People versus Jordan Miller.
hey, Peter, Richard, McGill, for people.
Ron Brown appearing on behalf of Jordan Miller. Green
Thank
sheet.
you, ma'am. Yes, Mr. Brown.
Please state your name.
Jordan Miller.
We'd ask for the adjournment to obtain additional discovery and review it.
Council approach. Conference in this matter will be adjourned August 7th,
Thank you, Your Honor.
2025, 9 a.m. Bond continued.
I'll talk to my client.
Court calls case People versus Lanish. I got that right. Mitchell.
That's for the people. This is the public defender on behalf of Ms. Mitchell, who's approaching now. Your Honor, we are asking for an adjournment. I know that Ms. Douglas has been working tirelessly to try to get us the video discovery on this case, but it is still outstanding from several agencies. I also received a bond violation report, which I assume the court is looking at now.
Yeah.
Ms. Mitchell did provide me with her medical marijuana card. I do have it if the court wishes to look at it. It is valid. I showed this to Ms. Douglas, and I'd asked her to provide a copy to Community Corrections.
Yes.
There was some misunderstanding regarding that, but she does now have a valid medical card.
How much time were you looking for, Ms. Allen? I realize you guys are trying to work on this, but
Yeah.
how much more time did you need?
Yes, Your Honor, I've had, for some reason, trouble getting video on it. I got some more this morning. If we could have a couple weeks, I do want to look at it because the video I had before was not of what I was expecting it to be of.
Okay.
So, I just want to make sure we're actually getting to the council.
Good, she said, yeah, okay. August 7th, 2025, 9 a.m.
August 7th.
Bond will continue. Thank you. Court calls case People versus Antoine Patterson.
Families end up, we have the people standing for the mother of the
And Assistant Public Defender Jay Bellinger on behalf of Mr. Patterson, who approaches. Mr. Patterson, can you please state your name for the record?
Antoine Patterson, Senior. All right.
And
go ahead.
I'm sorry, Your Honor. My understanding is that there is an agreement today and my client will be taking a no contest plea. I have, I believe in your file, there should be a previous advice of rights. However, if the court is not in receipt of that, I do have an updated copy and I did sign that with my client's permission.
I don't know. Why don't we just have I want to make sure I didn't get the plea form before. But Okay, the plea form indicates that the defendant will be pleading no contest to the charge of domestic violence. Upon a successful plea to that charge, count one would be dismissed. Defendant is agreeing to 2 years probation, no contact with any minor children other than his biological children, but only through CPS recommendation or court order, and incidental contact at a bus stop. The offer is contingent upon there being no violations, no assault or contact with anyone since the assault that underlies the current case. Also, there is a sentence agreement, which I can't bind the court to, but for 7694A with all treatments recommended by probation. That's the court's entire understanding of the agreement.
That is our understanding as well, Your Honor. That's our understanding.
Seven to one.
You solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Go ahead and state and spell your name again.
Antoine Patterson Sr. That's ANTUAN
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
All right. Two things about it I have to make sure you understand. First thing you need to understand is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Basis for the no contest plea?
Fear of potential civil liability, Your Honor.
All right. So, sir, understanding all of that, you still do wish to plead no contest?
Yes, sir.
And to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind?
Yes, sir.
You signed an advice of rights form?
Yes, sir.
Any questions regarding those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
All right. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 24-52383. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if I accept your plea, from the time of this plea to the time that you are sentenced, if there is indeed a violation or misconduct as defined by the Michigan court rules, and you're engaged in that two things. One, you would not be able to withdraw your plea. You understand that?
Yes, sir.
And you understand any sentence agreement and or recommendation the court would no longer be bound by?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other? And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right. We'll accept the defendant's plea of no contest to count 2. My paperwork. Plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A for probation, or I'm sorry, 14B probation. Sentencing in this matter will be
August 18th at 10 a.m. with Judge Washington.
August 18, 2025, 10 a.m. Judge Washington. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Danielle Pressey.
After Monica, people.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Fressy. We say your name for the record. Danielle Pressy? Thank you.
All right.
Your Honor, I'm sitting in for Mr. Gaddy. We're asking for an adjournment. There's some mitigation information that's been being finalized and going to be presented to the prosecutor.
All right.
Shortly.
Probable cause conference will be adjourned August 7th, 2025, 9 a.m.
Thank you, Judge. Thank you.
Thank you, Your Honor.
August.
Bond will continue. Court does call the case, People versus Jody Ann Ross.
And Lord Yaki, assist.
Jody and Russell, can you hear me?
Yes, we can hear you. Thank you.
Okay, no problem.
You're requesting an adjournment.
I am, Your Honor.
I will adjourn the probable cause conference August 7th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
And Laura Yagi, Assistant Public Defender, with on behalf of Mr. Schultz. Mr. Schultz, can you state your name for the court?
Motorola. Mr. Schultz? If that's you, wave your hand. Oh, there you go.
Yep.
You're on your. Okay, state your name.
Jeremy Schultz.
All right, very good.
Your Honor, I'm requesting an adjournment in these matters for some updated paperwork and continued conversation with APA.
All right. In both cases, probable cause will be adjourned to August 7th, 2025, 9 a.m. Bond continues.
Your Honor, can I?
What, sir?
I was gonna say I'm going back to work. I was wondering if I could do it via Zoom for the 7th.
You talk to your attorney about that.
I'll file it for you, Mr. Schultz. We'll follow up.
Okay?
All right, thank you.
Thank you.
Our call case, People versus Joseph Smith. No.
And Assistant Public Defender Nick Bukovich on behalf of Mrs. Smith, who's appearing via Zoom.
You don't have that.
I did have a contact with Mr. Smith before the docket started, indicating that he was on the Zoom.
He was on it?
I'm here.
Yes.
I'm here.
Oh, that's you. Okay.
Mr. Smith, can you please state your name for the record?
Joseph Smith.
All right. Okay, what are we doing in this case?
At the time, Your Honor, be requesting an adjournment for some further negotiations and also determine if there's any outstanding video discovery in this matter.
All right.
I do have a green sheet for you.
I'll adjourn this matter to August 7th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Myra South.
Mr. Douglas for the people.
Hello,
Hello, state your,
my name is Alex Parks. I'm requesting permission to practice
again?
again. Oh, come on, girl.
Why are you doing it again?
I only did it once.
Who's your supervisor?
Miss Hannah Apple.
Did Miss Apple tell you you only needed, that I only needed it once per session?
I
Did
must
she
have,
tell you
she
that
must
or
have
no?
told
Don't
me.
defend her. Did she tell you that?
I'm sitting in for Mr. Daddy.
She's,
That's on me.
So are you normally with Miss Apple or Mr. Gaddy?
Mr. Gaddy.
Okay, now I get it. Okay. It's not Miss Apple's fault. Okay. All right, you're requesting an adjournment.
Yes, we are.
All right. Probable cause conference will be adjourned August 7th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, ma'am. Court does call the case of the People versus Virgil Stafford.
Just another person.
Oh, there he is.
This is public defender Hannah Apple, appearing on behalf of Mr. Stafford, who's from down. Mr. Stafford, will you state your name for the record?
Virgil Stafford.
In your honor, we have reached a resolution.
Yes, I do see. He's going to plead guilty to,
An attempt, count two, an attempt resisting.
yeah, the problem is all right, I'll fix it. But it just states next to the primary charge. The PAC code is for the attempt, but got it. Okay.
Thank you.
He's going to be pleading guilty to the charge of attempted resisting and obstructing an officer, the 1-year offense. Upon a successful plea to that charge, that count two, count one would be dismissed. There is an agreement by the defendant that he will comply with all court orders for mental health treatment, comply with all medication plans. Defendant has a probate case, I'll just leave it there, that was transferred to Genesee County in June of this year. That's the court's full understanding.
Yes, Your Honor. That's correct, Judge. Thank you.
All right. May I have him sworn?
Solemnly swear or affirm the testimony about the truth, whole truth, and nothing but truth, so.
Yes.
Lower your hand, spell and say your name again.
Virgil Virgil Stafford, Stafford.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Bravo in the 15th District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights. Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Okay. Were you on probation at the time of this offense?
Yes.
All right. You understand that your entry of a plea in this case could be considered a violation of that probation. You understand that if it is considered a violation, that court could sentence you to the maximum allowable under that other charge.
Yes.
And understanding that, you still wish to plead guilty to this charge?
Yes.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense, sir?
Yes.
On the date of January 16, 2025, at the location of 300 Briarwood Circle, City of Ann Arbor, Washtenaw County, State of Michigan, did you come into contact with officers of the Ann Arbor Police Department?
Yes.
What happened?
Sorry.
Go ahead. You may blood here.
Thank you, Judge. On that date and time, you came into officers that were with the Ann Arbor Police Department, correct?
Yes.
And you knew that they were officers with AAPD?
Yes.
Okay, and they ultimately asked you to step out of your vehicle, correct?
Yes.
Okay, and you complied with that, but then they informed you that they were going to detain you, correct?
Yes.
And to place your hands behind your back?
Yes.
Okay, and you did not comply with that order, correct?
Yes.
Great.
All right.
Defense is satisfied.
Okay. Very good. Sir, if I accept your plea, I do have to advise you that if between today's date and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you first of all would not be entitled to withdraw your plea. And secondly, any sentence agreement or evaluation, the court would no longer be bound by. You understand that?
Yes.
All right. Counsel, are you aware of any other plea promises, threats, or other inducements which have caused this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, sir.
Defense is satisfied. Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
July 29th at 9 a.m. with Judge Bell.
July 29, 2025. What time, I'm sorry?
9 a.m.
9 a.m. with Judge Valwell. And will continue. Thank
Thank you, Judge.
Court does call the case of the people versus Darnell Taylor.
Alexander, on behalf of Your Honor, she is in the hallway charging his tether.
Doing what?
Charging his tether.
On our bill? Go ahead. I'm talking about. That's why our DT bill's so high. People come here to charge it.
Thank you for my appearance on maybe. On behalf of Mr. Taylor, will you state your name for the record?
Darnell Taylor.
Thank you. Your Honor, we are asking.
How long was he charging for?
Oh, maybe 15, 20 minutes?
35 minutes.
35, just kidding, on my time.
35? Figure out the DT rates. Give me a number. We'll make it pay. All right, go ahead.
Your Honor, Mr. Taylor is asking that this matter be set for a preliminary exam.
Media has not been sent over to defense counsel, nor has the 911 call. The media notice was made, I believe, 2 days ago, and the 911 call still has not come in yet, so they do not have media discovery nor the 911 call.
And Your Honor, that is correct. I informed Mr. Taylor of that. I informed him that the court would be asking if discovery is complete. We do not have the video. Mr. Taylor is still insisting and requesting that the court proceed with the preliminary exam. I fully advised him of the risks of that, considering one of the allegations is from the back of the patrol vehicle. We do not have video of that, but he is asking that the matter be set for an exam.
Sir, you understand that could be a problem for you? Because if the discovery comes in and people have it, your counsel hasn't had a chance to look at it, you're not going to get an adjournment of these proceedings.
Yeah, I understand.
You understand that?
Yes, Sean.
Do you think it might be better that your attorney would be able to look at what it is, particularly since some of it was involved in what I understand the back of a police vehicle, prior to making or being able to fully advise you as to how to proceed?
Yeah, Sean, I understand. I mean, at the end of the day, I honestly don't think it's going to make a difference.
So you got your law degree where?
I don't.
Yeah. And I think she said it, so it's not really impinging on your privilege. She's advised you that you probably should wait till they can fully assess it.
Did I advise you of that?
Yeah, she did.
Okay.
Don't you think it might be advisable for you to follow your lawyer's advice?
I do, Your Honor. But at the end of the day, I mean, I know what I did.
Well, no, whoa. I don't want you.
Okay. Well, I didn't do.
I do. No. Hold on. Here's what we're going to do. Over your objection, I'm going to adjourn it. I'm going to make sure that it's fair to you and that you have what you need to make a proper call rather than rushing into it. Okay.
I understand. My main thing was I'm on this tether and
I know, but you don't want a circumstance where, and I'm not saying that it will, things can get much worse for you. Let your attorneys do their job for you. Okay.
All right.
You got good attorneys around you. Let them do their job. Okay.
All right, Your Honor.
All right. So we think we'll have that by when?
Probably sometime next week, Your Honor.
Okay. So if you get it next week, here's what I'll do. I won't put it out far. I'll put it out, instead of going to the 7th, I'll go to July 31st.
Thank you.
Okay. 2025, 9 a.m. And then at that point, after you've seen everything that's there and your attorney, most importantly, has seen it, then you can make a decision.
Thank you, Judge Simpson.
Fair enough?
Yes, sir.
All right. And just because you actually listen to me, I'm not going to make you pay for the use of electricity.
I appreciate
All right. Take care.
Thank you.
Court calls case people versus Vershawn Vincent.
That's the line for the people.
Sorry. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Vinson. Your Honor, I don't believe with Mr. Vinson. I will take the blame for this one. Mr. Vinson typically appears on Zoom. That was my apologies in missing the deadline. I submitted it late. I've had communications with Mr. Vinson up and through today and just a few minutes ago. He lives in Detroit. He does not have transportation. But he was not able to make it here today. He tried everything he could over the last 24 hours to get a ride. But unfortunately, he could not appear in person. We do have a misdemeanor resolution on this case. We just need Mr. Vinson to get here.
Gosh, she's so nice and eloquent. I hate being nice. People have any objection if I adjourn this out, given those circumstances? Who is it, Londi?
Yeah.
Oh, boy. This could get bad.
The only problem is Mr. Vincent has a very significant history of failing to appear.
He does, but I think since
Since he's been coming on Zoom, it's been better,
yes, exactly. And
but it's still not great.
If I could let the court know,
wow.
just one additional thing. Mr. Vinson, we had a lengthy conversation yesterday. He's prepared to accept the offer. I informed him that we'd be asking for one more adjournment. And then my request is that he appear in person in 2 weeks at the adjourned date so that he can sign the waivers. We can make sure to have that conversation so that everything is signed and done. He informs me that he'd be able to get a ride, that's enough notice, and he would be here. So if the court is gracious enough not to issue the warrant, I will ensure that everything that I can do, that he is here in person and he has enough time.
Noting the people's reluctance to agree, and I understand, and looking at the file that he's had some issues, I'm going to grant the request. I'm going to adjourn it out to July 31st, 2025, 9 a.m.
Thank you.
Continue. Thank you.
Thank you, Judge.
That it?
That's it.
Then what?
And
I get a break? All right, court stands in recess.
all right.
Good job, baby. I like my answer.
You may be seated.